Brooks.
Here.
Frizzalone.
Yes.
Harris. Markham. Moran.
Present.
Mustis.
Here.
Ogalla. Here. Summers. Trainier.
Here.
And Winfrey, you do have a quorum. Thank you. Mike.
I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we're going to flip the script a little bit here. The discussion on the expungement fair is going to be first instead of the bond issuance piece, Judge.
Good morning, everybody.
Morning.
I don't know how much background I need to give at this point. I don't know what you all know about expungements from a legal perspective, but just very briefly, expungements is a legal tool. It's a legal remedy that can be used in certain circumstances where somebody who's gotten themselves in a bit of trouble can potentially have their records expunged or cleared, so that from the point of view of future employers, they won't have access to the information of what happened to this individual, so that it would be easier for that individual to go out and obtain meaningful employment and become a productive member of our community. I think that's very important. I wanted to tell you right now at the outset, this is not for serious crimes or for serious criminals. This is for people who got into a tight spot, either pled guilty or were found guilty, and were given usually supervision, occasionally conditional discharge when we're talking about sealing the records. But things like maybe simple battery, theft, revoked, suspended licenses, things like that. This will not include domestic battery, will not include DUIs. Those records must be maintained forever, and for obvious reasons. But if these people fit specific parameters, including that they have successfully completed all of their conditions of supervision or conditional discharge, and at least 2 to 3 years has gone by, depending on the statute as to the individual offense, has gone by without any other issues, then these people should be given the opportunity to go out and seek meaningful employment. Now, so there is this by law, a way for these people to file petitions for expungement. However, it can be very daunting. It can be very difficult, a complex procedure to go through. And there are 24 judicial circuits in the state of Illinois. There's just a couple of them that do what we can commonly call expungement fair. They can call it new beginnings. There's several different names that you can give it, but we've sort of chosen on Fresh Start as a name, and where we are going to plan this fair, this initiative, where and we have been planning this, by the way, since last July. We've been meeting with this. Your representative on that committee has been Mr. Brooks, who's been there every meeting, has been very important to us in helping us, because he has done so many of these through his church and his community. He's given us some great ideas. But we're going to do this initiative. Right now, the date is set for June 22nd of 2019, where we will have things set up on the first floor of the courthouse where people will be able to come in and go through the process, where there will be everybody from all the departments that are necessary under the judiciary, along with Circuit Clerk Andrea Chasteen, who's been terrific on this, and she's been to every meeting, and she's taken a primary role in this also. The Sheriff's Department will be included at some point to discuss security issues as we go through this planning process. We expect to limit the number of people that will be able to service on June 22nd date. It's a Saturday. We expect it to be from about 10 a.m. to 4 p.m. p.m. We're going to have many employees that will be working that day. We're also going to need probably a couple of dozen at least volunteers who we will have trained by an outfit up in Chicago who does this, to train these volunteers to be sure that they get bring in all the people in, find out if they're eligible, and if they're eligible, file the petition on their behalf, and then go from there. The law is very specific. If they are eligible, they will file the petition, and we will do everything that we can to be sure that under the law that their petitions would be granted if they're eligible. However, the statute also says, and rightfully so, that objections can be made to those petitions by either the State's Attorney's Office or the Attorney General's Office or the Illinois State Police, and they would have the ability to file those objections within 60 days. And on that June 22nd date at the fair, we actually give court dates to these people after 60 days so that they can come into court and at that point in time have their petition ruled upon. Jackie?
You mentioned objections, and you mentioned a couple of potential groups that could object. I'm just assuming there might be a victim involved somewhere along the line. Either a store owner, if it was a minor theft, or you mentioned battery but non-spousal. Let's say it's two neighbors fighting. Do those individuals that might have been involved in the altercation or the situation, do they get advised that this person has applied for expungement? And I'm just curious because I don't know exactly which types of offenses are eligible.
And that's something important, that information that we need to get out there. We are currently preparing a pamphlet, a brochure, that will provide everybody with the at least the initial knowledge they need to go through the pre-registration part of this, so they can determine if at the outset if they're eligible. Basically, the answer to your question is going to be no. There's nothing in the law that provides that they would be required to have notice, because the statute already contains the factors that are necessary that I mentioned before, that they have done everything that they need to do, including if there's a victim in theft, that for instance, that the store has been reimbursed completely, restitution's been fully paid, whatever's been done, and again, we're not talking about aggravated battery or domestic battery, we're talking about the simple battery, so that usually doesn't mean a lot of medical, for instance, but that stuff all could have been part of their conditional discharge or more likely supervision if that was the sentence.
Okay, and I'd like to volunteer.
Terrific. All right. And it's important because when we get those, all of you are some of the first people that we want to get this information to. And quite frankly, this has been planned, as I mentioned, since last July, and we're working on it still, but this is the very first moment that we've gone public with this, and we want the public to know this is coming. We want them to know in every way possible that this is a possibility for them. This has been done, I know of 2 other circuits. Cook County does it, and a circuit down south does it. So not a lot of circuits have done this, but we know that it has been incredibly successful in those other circuits.
Jim.
You're talking about expungement for people who actually have been maybe convicted of something, of a minor crime.
If I may, before you ask your question, if they have received supervision, they were not convicted.
Okay.
And expungement applies basically to those who've been given supervision. But if they're not eligible for expungement because they received a conviction, the next step is whether or not they're eligible to have their conviction sealed, which is still, from an employment standpoint, very important.
Okay. Well, the other thing I think is important from an employment standpoint is having arrest expunged. Now, very many people can be falsely accused of something, they're arrested, it shows they were arrested. What it doesn't show is that when they got in front of a judge and the judge seen the facts and there were no facts, that the judge will dismiss the case.
You are correct. If the case is dismissed for any reason, if they are acquitted, if they're found not guilty at trial, a lot of defendants in that situation they might leave happy, but they might leave not knowing that that there's still going to be a record of this. There's still going to be,
Clouds, Jim.
that needs to be expunged.
Well, that's what I'm trying to get out there. If you're going to help with this, if a person was arrested and it was dismissed, that arrest goes on the record unless it's expunged.
Correct.
The arrest can be expunged, I guess.
And by the way,
Next question, is that a part of this?
And by the way, expungement means, as part of this process, that order means that whoever has their whatever law enforcement agency has their fingerprints, for instance, they're destroyed.
Yeah. So I just want to make it clear that, very often people are arrested mistakenly. I don't want to say mistakenly. They thought there was probable cause at the time, but when they got into the case, there was no merit to it or nothing that supported it factually, and it's dismissed. And now I'm going to get into an area that may be a little touchy. So if somebody is arrested or accused or falsely accused of domestic violence, and that goes for men and women, it goes both ways, is that eligible to be expunged? Because, people in the heat of an argument or spouse, they'll sometimes do things they probably shouldn't.
If you are acquitted or if the case is dismissed, the answer is yes, because the case never happened in court to a finding of guilt, so the answer is yes. If there is a plea of guilty, though, it will not be eligible for
Correct.
expungement.
I understand it. The other thing I want to know is sex crimes. Are they treated differently? I mean, if somebody was found guilty of having pictures, say child pornography pictures of maybe, and did wind up receiving probation and because they went into counseling, whatever. Is that eligible?
No, those
Good.
sorts
Okay, I
of
wanted to
felony
make sure.
convictions are not. That would, of course, be considered to be a serious crime. A
serious
violent crime, sex crime, those crimes would not be eligible upon conviction.
Good, okay.
Okay.
One more question?
Hopefully only one more. How long has this been a law? Because you just mentioned like Cook County and one other county, and how long has this been on the books?
It's been on the books for
Long.
decades,
Yeah.
but this is the first time that people are starting, circuits are starting to do fairs or initiatives to bring people,
What caused you to do this?
what caused me to do this?
Injustice, yeah.
I'm good with it. I'm
Look,
all
if you
in
were-
support.
if you were
I'm just
19
like,
years-
what caused your light bulb to
If
go
you
on?
were
Let me
19 years
just
old
say
and
that.
got caught with some marijuana, should your whole life be ruined?
No.
Two things. One is that we have talked about this at the Conference of Chief Judges, of which I've been a member for 6 years. So this has been talked about occasionally, and I began liking the idea a while back, but it's a massive undertaking. It's just massive. And you have to bring all the employees in on a Saturday, the issue of payment or comp time, plus volunteers that will help out. It's a big undertaking, Jackie. And we're limited. And the other major thing is that our director of the Family Violence Coordinating Council is Leanne Lance. She came to me last year, probably June or July, and also made the suggestion and said that she wanted to be one of the ones that would spearhead it. And as soon as I had that volunteer, it really, in my mind, I thought, okay, then this is a good way to start this. So Leanne Lance gets a lot of credit for this too.
I do understand needing a chief volunteer. You know, you just do.
Okay, Don and then Jim.
Somebody has to push their button. I was going to say that probably you're seeing a lot more public interest in it because it used to be that for somebody to have a background investigation run on to do a job required you to be in some position where you had access to the money or funds or whatever for the company or whatever. Nowadays, every minimum wage job that's out there, just about, does a background investigation on their employees before they go to work there. So it's really having a bigger effect on the public now trying to find a job where they may have something that they can get off their record that won't keep them from getting a better position going forward, so.
That's exactly right, especially in an economy right now where there's jobs out there.
And nobody to do them.
I'm sorry, Jim?
If I could just make one other comment, and Reverend Brooks, you might want to chime in here. You should know there's been a lot of effort by churches, by other groups, to try to get expungements done. So they've been doing it. It's something that has been going on outside the court. I mean, so there has been a lot of effort. Workforce investment, I believe, refers people, because, a young person who was maybe caught with a small amount of marijuana, and now he's 19 and now he's 30. This is still on there and he's still not getting jobs because of it. But there has been a lot of efforts within communities. So and the reason I'm mentioning this is we just don't rely on this program. This will be a great program because it'll draw a lot of attention and a lot of people. We can get the word out. But Mr. Brooks has been involved in this for quite some time, getting young people, young adults, some of these things removed. So there has been a lot of effort. It's nothing new, just so you know.
I haven't seen anything anywhere in our county except Joliet. Now, maybe I don't subscribe to the right stuff.
Workforce helps. The Workforce Investment Board refer people, or they tell them, you need to get this expunged. Go over to Reverend Brooks's church, and he can help
Then
you,
go to
or whatever.
legal aid and some
Right.
other places.
Yeah.
But now it's more of a countywide effort.
We fully
spearheaded by the
anticipate
Justice Department.
that everything that Jim just mentioned in churches, the charitable agencies, workforce, we expect to use them to bring people into us, because as good of work as they have all done, and I give Herb Brooks a ton of credit for everything that he's been doing, as he's mentioned himself, and he will tell you, there's nothing like having it all arranged where you come to the courthouse, one-stop shopping, and, you can walk out with an idea if you're going to be expunged.
I was afraid, and thank you, Judge. I've been doing it for almost 20 years, and thank you for inviting me to this, because if there's no teachers here to judge my grammar, yours is much gooder. Trust me, it is. So it's a wonderful program. But I wanted to ask, though, and let you know, we do have a website. I don't know if Andrea have updated the change of the date. It was June 8, now it's 22, but it's also pre-registration. So I think it's a much better program, even though we've been doing it for almost 20 years. What we can accomplish on June 22nd in one day is a much better program. So I do appreciate that.
Thank you, and thank you. But what Herb and I both want to get out also is that this is not for serious offenses. This is not something that the public needs to be concerned about in terms of expunging records of those serious offenses. We also want to get out there that this is not some sort of trick by government to bring in people who, have arrest warrants. This is not something like that. This is truly a good program that's going to be great for the county and great for the individuals. On the other hand, if you do have a warrant out there, we don't want you showing up at this expungement fair. This is not going to be for you, because if you have some current difficulties, then you're not in compliance with the rules that would make you eligible for the expungement to begin with. So we want to be sure that, and that's what this pre-registration will help us and help the individual determine. And we expect that we will have whatever our limit is, 100, 150, 200, maybe 150 is what we're talking about currently. I predict that we will be turning a significant number away, which we all feel bad about, but we do want to get one of these under our belts first. And the space is going to be an issue, because we want to keep this on the first floor of the courthouse, because it's going to be on a Saturday, it's going to be after holiday court, and we don't want people up necessarily in the second, third, or fourth floors, so we're going to try to keep this down from a security standpoint, also on the first floor, and we're going to use the jury assembly room. We've already walked through everything, and the 3 courtrooms on the first floor, the hallway space, the bailiff space, we're going to use it all. But even outside if we need to. We'll have tents if we need to. But we want to be sure that we have the space that will handle however many. After we're done with this one, we'll know what we can handle after that, and we'll want to expand. The 3rd district that is doing this right, has been doing this for 4 or 5 years, they have multiple counties in their judicial circuit, and they go around every year to a different county to do theirs. Their combined population of all their counties in their circuit is probably less than half of what Will County is. And they get hundreds every year.
Wow.
And so this is something it's not a small thing.
Tyler?
My question is this only open to people who went through our circuit, or is it open to anybody in the state of Illinois, or who's eligible to come?
It's open to anybody who has a Will County case. So whether or not you're a resident or a non-resident, if you roll through Will County, had an issue, and it happened in Will County, if it's a Will County file, then it's a Will County, then you can do it, wherever you come from.
Yeah, okay.
One more question. I'm sure Leanne's already on this. You mentioned, or Herb mentioned about it being on Andrea's webpage. Is there a flyer? Is there some stuff we can promote on Facebook? I mean, it's about getting it in front of the people that would want to apply.
We absolutely want you to get to your constituents and let them know this is available. This is the nut of the pamphlet that we're preparing.
Okay.
There's going to be some changes made. I just talked to Roger Holland. We're having a meeting next Wednesday as our next meeting. I expect that we'll have everything worked out then, and then I expect that this information, certainly in the month of January, will be given to everybody. The timing of this is we want to be sure this gets out to the public, however it's going to happen, through agencies, through churches, through you, through media, in the next 60 days or so. Then we'll start the pre-registration process immediately after that, and then it will give us a couple of months to go through that process before we actually get to the actual event in June. So that's our timing right now. We'll need to find volunteers, and I don't think we're going to have a problem getting those volunteers. We'll get a date probably sometime a bit later, maybe March or April, where we'll have the firm from Chicago come in and do the training of everybody on one time that will train for these purposes. The state's attorney will be involved also, public defender's office, probation, interpreters, bailiffs, most of my departments, and then, as I said, technology, record keeping is going to be way up there, and those 2 words immediately go to Andrea Chastain and her people. She is going to be very, very important to this process. Andrea, you're here, aren't you? Thank you. Mm-hmm. Thank you very much, Andrea, for your help. And she has, I was told she agreed to be the captain of the whole pre-registration process, so I hope that's true, because I just said it out loud. So Andrea is very important to this. So I really appreciate the time. I could talk for a long time, but I saw your agenda, so I think I probably overstayed my welcome.
Before you leave us, Judge, are there any more questions on this panel? No? Okay, Julie?
I was wondering, does that include minor drug offenses, for example, marijuana? We know a lot of young adults that make a mistake, and later on it might cause to haunt them. So.
That's a good question, and the answer is yes, it can. In fact, if it's a relatively minor drug-related offense like possession of marijuana, something like that, it absolutely is intended for those individuals, and in fact, by the expungement statute, it's required that before they can get their records expunged, they need to pass a drug test. So, and we intend to have that set up, either to have it done during the pre-registration process before June 22nd, or possibly it might be done on that day as well. So yes, it is intended for people with those issues.
Okay. We have one more question here, and then we're going to let you go.
Judge, since Ms. Berkowitz brought this up, of course, things like marijuana has changed a little bit over the years.
It's gonna keep changing.
So now, there's not necessarily arrests made, or many municipalities, and the county, we make them ordinance violations. They come in, I guess that's like getting a ticket. I mean, is there records of that? I mean, I'm just wondering, people who have had like small amounts of marijuana, and there's other crimes, it could be alcohol, it could be whatever, it could be a number. If it's an ordinance violation, should that person be concerned? Is that on record? I'm just...
It's a relatively new law, maybe a year and a half, maybe 2.5 years. I'm not really sure. I'm sure. Pardon me?
I think we've done the ordinance thing.
Maybe time flies, I know, but maybe it was that long. But for those individuals, since that law was passed, and go through that violation, their records are automatically expunged by the clerk's office after, is it 1 year, Andrea?
Yeah, those are on the CL cases.
Yeah. It's a specific line of cases that they're called CL cases that are just for that purpose, for relatively minor amounts of possession of marijuana.
Okay, Mark?
Who do we contact to volunteer? Are you?
Who's getting your name right now?
We will, Roger Holland probably just wrote your name down, Mark.
Okay.
But,
I'll remember, don't worry.
but we'll get the information out. Tyler, being that Mr. Markham, as chairman of the Judicial Committee, I'm hoping that he'll be able to start attending these meetings, and next one's next Wednesday, and we'll get the time out. Herb will be there, and I'm hoping that they will be my liaison to your board. So to look for...
Count on them.
Right.
Tyler's got me.
I can also help coordinate for the
Thanks,
board.
Maura. Appreciate it.
Appreciate that. Okay. Anything else for us, Judge?
Not from me.
Okay,
I'm
thank you so much for agreeing to be here this morning.
Thank you.
Appreciate that. Excuse me. Okay, we're going to flip back then to the bond issuance.
Good morning.
Morning, Karen, Rashawn.
There's an attachment on the agenda, but I also printed out. Oh, you're let me get one. So last week, we talked a little bit about our next bond issuance, and we had some questions come up. So this is just a little bit more information that people had asked for. The first page is just an outline of what you'll have. So we can go to page 2. Page 2 is a history of how we've spent our RTA dollars from 2015 through 2018 fiscal years. We spent roughly half of the RTA revenue, and this includes not only what comes in every year, but some of the reserve funds on road construction projects. The debt service for the 2010 bonds, which is we call them the road bonds, that is committed from RTA funds. The other piece that we used, and we used it a little bit not as expected. We had always intended to use a piece of the RTA revenue to meet debt service requirements. What happened when we issued the bonds in 2016 was they were issued in August. There was no payment due in 2016. However, we neglected to plan for the abatement, which had to happen that fall. That abatement was a little over $11 million. Unfortunately, we had hoped to use some RTA funds to fund part of the public safety complex. There's only one pot of money, so we can't use it for multiple purposes. So in 2016, we needed to use some RTA funds to abate the bonds. And 17 and 18, those amounts are for debt service. The other thing that happened during this, and this is something that is difficult to plan for, there's other things going on at the county besides these building projects. So one of the other things that took up quite a bit of money in the RTA revenue was the radio system. It was almost $6 million. So that was taken out of the RTA funds. So while we had initially talked about paying for cash for part of the public safety complex, we didn't have the funds available to do that. We had to meet our requirement for abatement. Does anyone have any questions about that?
Did you have?
Yeah, not my understanding. So I'm still, you got a lot of numbers, still not adding up to me. If we use 11 and 2.6 and 2.8, we use that, we talked about paying cash for the $32 million that we spent, because we had a big chunk in RTA that we thought we could use. I realized we used a portion of that, but what about the other money that we've been using? The way this lays out on this sheet, everything was paid for by the bond proceeds.
Yes. My recollection was that initially the public safety complex was not all the way at 32 million. My recollection is that we were going to use 15 million in RTA funds to pay for it. And we've used just about 15 between the abatement and the radio. Now, it's a little different combination, but I mean, there's only so much money. I think the public safety project continued to grow. It ended up being 30-some million dollars. I don't think that was the intent when we first started. That's my recollection. This information that I provided for you, Rashawn helped me put it together. It was reviewed by Melissa. It was reviewed by the people that manage the capital project. So we all are of a similar thought that we did what we could with the funds we had available.
I also see money coming out in 2018 for animal control building out of bond proceeds. Why would that happen?
What was the last thing you said, Mike?
Animal control,
No, the last part of it.
there's bond proceeds paying,
You're on the next page.
Oh.
Okay. All right. Can we get through this and then we'll jump?
Jim?
Yeah, just for clarification, Karen, we talked about paying for cash for the law enforcement facility. But I don't recollect us ever saying, we said basically it's going to come out of cash reserves. We didn't say RTA, we didn't say, so as a matter of fact, I don't think we ever mentioned the RTA pot of money. We just said it'll come out of cash reserves. But it appears you're saying that it came out of the RTA pot of money, because there was other reserves there. I mean, the county has other cash reserves.
Well, the corporate fund has a cash reserve and motor fuel, but motor fuel is not intended for
restricted,
this.
yes.
Exactly.
That's restricted.
I mean, the other thing that's happening in this is the Department of Transportation is being required to identify funds for the Weber Road project. There's only so much money. And again, I go back, our understanding was that we were pay up to 15 million in cash, not for the whole building.
I think you're correct. That we talked about a portion would be paid for, and I do think we said, well, at least half could be paid out of cash reserve. The other cut could come out of. So, I agree with you. I recollect those conversations. And then as it went on, we said, well, 32 million would come out of cash reserves. Probably would have been easier if it would have been explained back then that it was coming out of bond proceeds. But
we did talk about bond proceeds at one point, because we said we were going to take the bond proceeds temporarily and then replenish the bond proceeds with the cash.
yeah, I recollect that conversation also, yes.
Which never got replenished.
Well, we did a small amount of that, but not,
We did
because we could only go back so far.
Because we were
Expenses-
only going to go back for the date of the issue. I mean, we
A
did
few
go
months
back.
before the ordinance.
But
Yeah.
also let me say
There's
this.
restrictions for us on that.
And I guess, Mike, this is, we didn't discuss, the financing and the abatement part of the bonds and so forth, that had to be funded. Matter of fact, even in this year's budget, we had to have that discussion after the budget was presented by the county executive, because we recognize there's going to be this shortfall if we don't address it now. So I do understand what happened. I understand that we may not have had an understanding, or maybe, I want to say maybe you never told us, or maybe there was other conversations, I don't know. But my point is that, you know, obviously it seems Melissa and the finance office were aware of it. So I guess what I'm going to say is that, yeah, I understand that it's not exactly what we thought it was going to be, but it is what it is. I mean, we had to fund these
Right,
things.
some kind of way.
Now, Mike, you still think there's a little more money there
In 2016, when we did do this issuance, I want to let everybody know, the abatement, I forgot about the abatement.
We all did.
But
Yeah, we can share them.
that was something that, when that happened, we kind of, we gathered together, we put our heads together, and that's what we did to take care of that. But that was $11 million that was unaccounted for us.
For new people, I don't know if you want to explain what the abatement is.
And maybe for us old people too, because we always.
Go ahead, Melissa.
Go ahead, Karen.
When we issue, when the county has the ability to issue government
General obligation.
general obligation alternate revenue bonds. The bonds are guaranteed is a general obligation of the county. If we do not abate, and abate means we take the money and set it aside for the next year's payment. So last October, we put the money aside in a special fund for this year's debt service. If we don't take that action, the amount of debt service gets automatically added to property taxes.
Yeah. So, you know,
Automatically.
I think an easier way of saying it is that we pledge property tax for the bonds, but we use alternate revenues to actually pay them.
So
We don't use the real estate, so you have to abate it back.
Right.
To not use, with actual dollars, not to use the real estate taxes. Okay.
So when we didn't do that.
Oh, we did? No. Yes,
You're saying we didn't abate the levy?
No.
We did later, we forgot.
We did
And
not
then we went
plan
back and
for it.
corrected.
We didn't. Oh, you just forgot that you did.
The financing of it.
Right. When we issued the bonds in August, we were focused on we didn't have to make a payment till next year.
Right.
We did not plan for it. Once we realized that, we immediately abated the money. I mean, it was abated with the rest of the bonds. So we did what we were supposed to do.
So just to, in layman's terms, make it real simple, just think of it as your house mortgage. So you plan to buy a house. You have your escrow account. You know that payment for that next year is going to be X amount of dollars. So you want to pre-plan and go ahead and set that money aside, put it away in your quote-unquote escrow account, so it's already there for the next year when you came. This is simply what we had to do once those bonds had been issued in 2016. We had to set that money aside because we knew that that first payment would be coming due the following year.
It's legally required.
Yes.
Yes.
We didn't plan for that, so there was some scrambling.
Yes.
To find that 11 million to put away. Now I understand.
Okay. Okay.
If there's no more questions, can we move to the next page? And I think this is where Mr. Frizzle's next question was. This is how we've spent down the bond proceeds. Sorry, I'll just by year, by project. So I believe for the animal control, one of the things that we did was there was a resolution that because the animal control, because the animal control budget did not include the building, we were going to use bond proceeds to help pay for their portion of it, and they're going to reimburse the bond fund.
Right.
There was a resolution, now I didn't attach that here or look up the number, but.
We couldn't amend the budget at that time.
Right.
Based on Mary's opinion.
So this was just to get them started. There isn't any intent that they will spend any more than this. They'll be spending their own funds
Money, yeah,
because
they
it's
have
in the
some set aside.
2019 budget.
Right.
So you can see in 2016, we issued bonds of $175 million. We received a premium. We had some expenses. The net of that was $205 million. We spent a little over 8.6 million in 2016, 34.6 million in 2017, 60.1 million in 2018. When I did this, there was $108 million left in the bond proceeds. We're up to a little over $10 million a month on the courthouse. I mean, when they're moving fast and furious, we're paying for that. So we do anticipate that this 108 will be spent down.
Right, as we get closer to the end of the project.
The rule of thumb is the bond proceeds should be spent within about 3 years of your issuance, so we have till August. If we go a little past that, I think there's a little leeway, but the bulk of it should be spent. What we don't want to happen is that there be a, oops, we have to stop now and go through the whole process to have an intent resolution and do all the public, we want to issue now so we have funds on hand. The two projects are going at the same time. We want to make sure we have enough funds available, which takes us to the next page unless there's any questions.
I do have a...
Okay.
2016, the $8,604,000. Now, in our bond document and in some resolutions we have passed, because we didn't have the bond proceeds yet, we were using
RTA.
Cash. So out of that 8 million, how much of that was money that went back into the RTA?
I don't know the number off the top of my head.
But there should have been money that went back.
There was bills that the RTA reimbursed.
I'd be interested to know.
The bond funds reimbursed the RTA fund is the way it works.
Right. So
I don't know the dollar amount.
I'd just be interested how much that was.
Okay. I can get that for you.
Okay.
Mike?
So suffice it to say, we use no cash for the public safety complex. We use bond proceeds for the entire public safety complex, and we use bond proceeds for the debt service.
No, we cannot use bond proceeds for debt service. Instead of using cash for the public safety complex, we use that cash for debt service. You cannot use bond proceeds for debt service. It's restricted. Bond proceeds can only be spent on what you identify in your offering, which were capital projects. So I think there's a little flexibility on which capital projects,
right,
but it still can only be capital projects. You can't use it for operations. Okay.
Any other question, Mike?
And any other questions about the?
You sure? Are you really satisfied?
I think so.
Okay.
Okay.
And now we're down to the crux of the matter.
Okay. Which one is it?
This is our best estimate of what we have left on the courthouse and the health department projects. For the courthouse, the subcontractor, the cost of that work's $148 million. Construction itself, $32.5. So that comes to a subtotal of $181.4 million. That is for the court with build-out on floors 8 and 9. Added to that is what they consider owner's soft costs and FF&E, furniture and fixtures. So to outfit the inside of the building. That's another $24 million. So that brings the expected cost to $205. We've already paid $63 million, so we have remaining $142 million, or $142.3 million left to pay. I do want to point out that expected cost does not include the owner contingency, which is $9.6 million.
That's my question.
So if the number seems large, there's still the ability, we still have the projection that we could spend up to $9.6 million. We're not asking or suggesting that we would bond up to that amount. Does anybody have questions about that? Okay. So the health department, the numbers are a little bit more estimates. The courthouse, those numbers are pretty refined. We've done all the bids. We really have good numbers for everything. They do still make work order changes, but I don't think anything has changed the overall total. I think we've reduced a few things and increased a few things.
Yeah, there's a little cushion in
What's the
there, actually.
contingency in there?
I want to say it's 4.5 million in the construction part. And if you want to know any more than that, that's Dave.
We still could come closer to 30 when it gets right down to it.
We could, but I don't,
We may not, yeah.
I think I wouldn't suggest we bond for that at this point. So the health department, we haven't bid out a lot of it. We've done a few pieces of it. These estimates are best available for construction, demolition of the site, the abatement, 25.5 million. Owner costs, parking, soft costs, architectural fees, 5.5. Furniture, fixture, and equipment, another 2 million. So that's an expected cost of 33, and we've paid just about a little over 2 million, which leaves almost 31 million outstanding or remaining. So those combined are 173 million. We have 108, which brings us to 65.
Okay.
I've been talking with Wells Fargo, and what I asked and what they are trying to put together is that we would issue bonds to receive 65 million. So we wouldn't be issuing 65 million in bonds.
Depending on the payout, we might issue less. Mike?
We're going to estimate the premium.
Yes.
Right.
All right, so 65 million, I see that's potentially what we could need, although we may be $4 million short of that.
Right.
Right? So why would we bond for, including the contingency, or even all of this money right now? A lot of our payments are going to be next year. So why are we going to bond for the full amount right now and not half or?
Well, the intent the ordinance expires.
I understand the ordinance,
in April.
yeah.
The volatility in the market, which doesn't have a huge impact on long-term, it's more on short-term,
Right.
but it's still affecting the bond market. The other thing for me is we have other issues to address going forward. We have to have employees for the buildings we're building, and I think we have other things to focus on. If we have the 65 million, we should be able to pay for these 2 buildings and focus on other issues that we have coming up.
Mike?
Okay.
I think we talked about it at the last executive. We got the roof on the jail coming up.
Right.
They were talking about having enough funds to pay for that, and there could have been other projects. That's just my recollection. And from what I understood, it was going to be a pretty expensive roof that we were going to be raising, like a couple million.
4 million.
Oh, 4. So there's your 4 million contingency.
Yeah, I get that. I'm just wondering why we're doing it all now.
Yeah.
Well, if we don't do it now, then we have to go through the
Reauthorize.
process again. Where we, and that's I want to say it takes several months to do.
Yeah.
We have the ability to do it now, and I don't think anyone thinks 65 is too much. It's not, I don't think we're issuing debt for more than we're going to spend. That I would be concerned about. I agree with you that there's the potential that we could spend a little bit more than this, and we do have the ability to issue bank qualified at 10 million a year, but that's all you can do in a year. You can't issue any other debt. So for me, this is the opportunity. In the last quarter of 2018, and I'm pulling this information from what Wells Fargo provided for us, there wasn't a lot of bond activity at the municipal level. I think that this quarter might be the time to hit.
I agree with that, yeah, I agree with that.
And I don't know, for me, I would like to have this, I'd like to know that this is over and done with, and if we need to issue bonds, it'll be a small dollar amount.
And if we have the money left over, we have other projects that,
That we
we
would
got a
need to-
list from Joel that's 3 miles long.
So we abated last year
Yes.
for this year, based on 35 to 40 million. So now what do we do if we're gonna go out for 58?
Well, we'll have to identify where that's going to come from. That, I know we can pay the debt service, the abatement, we're going to have to, we have to work that out.
We've identified where that's coming, we've identified where.
The debt
those funds
service.
are- Yeah, we've identified where those funds are coming from when we finalize the budget,
As far
but,
as the debt service.
right,
But the abatement.
We
didn't-
haven't.
We didn't abate
we have,
this year
because
for
we didn't,
58.
because we
abated for
didn't,
35.
and that was a preliminary estimate, because we didn't have all of the information,
There'll be additional.
or the definite number that we would go out to bond for, so we'll have to plan, have to plan for that as well.
The corporate fund, we ended the year at a little under 25%. That could be a possible place to take a few $1 million from. I'd like to stay away from RTA if we can. I mean, I think Weber Road is coming up.
Yeah, we have some other big projects.
Even this new issuance, there's going to be some level of RTA that covers debt service, and that's going to go on for the 30 years of the bond term.
Yeah.
We had planned that already
Right,
anyway,
right.
based on potentially 275 total.
Right.
So that's okay. And we already planned for Weber Road. That money's sitting there.
Well,
Right.
and the other thing is, this issuance was built into the plan. We had always intended to do an issuance in 2019. So the 2016 bonds, the debt service payment drops in 2019 to accommodate debt
Allows us to
service
take
here.
new, so then we don't take on rebate.
Paying the debt service is not necessarily the challenge, it is the abatement.
Right.
So, I would hope to
We'll
bring
drop
back
one
to
bill
you
off.
next month a little bit more information about where we would cover the abatement from, if there needs to be any adjustment to the budget for debt service. We have some preliminary information from Wells Fargo. I mean, it looks like if we move forward, if the board agrees, that we're talking about maybe issuing bonds March 21st, which is a board meeting date. So we could all watch.
Watch the sale.
Well, maybe not during the meeting, that's probably not a good thing to be watching,
Run the
but maybe
ticker
we
on the
could put on
screen.
the overhead, because I have to tell you, the $175 million was the first one I did on my own. I'd helped Paul in the past, but it was very exciting to sit at my computer and watch the sales. Yeah.
See, come on, Jackie.
So are we prohibited from buying some of these bonds, and how do you do it?
Well, I can't sell them to you. You'd have to
You'd
go
have to
through
go to
a
your
broker.
financial
I mean,
planner.
a pretty good rate of return, so.
So check
Well,
with
it's a
your broker.
guaranteed rate of return, and they're tax exempt, which is what makes them attractive.
Yeah. So do you go to a broker like Edward Jones or something?
Yes.
That's the underwriting.
Beth Rice, are you here?
Yes. So I have I guess the first thing I'd like to ask for is if we have consensus here. Mary has suggested that we move this forward to the full board meeting, and she's going to research for us whether we need a resolution or not. I mean, we have the resolution or ordinance that allows the issuance, but we do have a lot of new board members. So
may need a
that's what I would
resolution.
ask, that if everyone's in agreement, that maybe we would move that forward.
Okay, is there anyone not in agreement? You have a question, Brooks? Go ahead.
What is the window? You mentioned March 21 for the bonding. What is the window that we have to go for the bonding?
The ordinance expires in April.
In April, okay.
So at that point, we have no authority. We have to start the whole process over again.
Okay.
It takes about 60 days from start to finish. We have to put together a preliminary offering statement, and then that goes out to the market to spike interest. And then there's a lot of documents that require legal review. I mean, there's a lot of back and forth.
Right here at the board, so go ahead.
They're 100,000.
Yeah.
What?
They're 100,000 minimum.
Oh, I got that much.
Okay. Is there any unreadiness?
safer
Is there any unreadiness in this group about moving that forward to the board?
Safer than my 401.
Yes, please.
I'll move to move the bond issue.
And a second. All those in favor?
Aye.
Any opposed?
Okay.
Thank you.
Just a few more things.
Okay.
So next month at the Finance Committee, I'd like to bring back the information about the co-managers. We talked about that last time. We had done a RFQ, we identified 5. I have received from Wells Fargo how they performed on the last issuance, and I think probably we might not use all 5 again, but I haven't had time to kind of really dig into it, and I want to have a conversation with Spear Financial to, to see what would best suit the county.
Okay, is there a question here, or no?
Oh, no,
Turn that
sorry,
on.
that
Oh,
was
okay,
before.
okay. Go ahead.
Bond counsel would be my recommendation, that we would continue to use Ray Fricke. However, we are going to look for another firm for disclosure counsel. The cost of that is not significant in the realm of the bond issuance. So Spear Financial has put out some requests for quotes on our behalf to firms that they work with regularly. So we can look at those and make a selection from that.
Okay.
I can't even read my handwriting. So the preliminary schedule that was provided by Wells, it would be that the sale would be on March 21st. I mean, it's a lot of moving pieces. We certainly could go a week later maybe, but I don't think we want to go into the month of April, because that is when the ordinance expires.
We would have to have a special board meeting in it.
Yeah, so I
No, let's go ahead
think,
now so we can clean it up.
and I think at the last meeting, and I hope again that you're comfortable with me continuing to move forward, working with Wells to kind of get this process going.
I am. Is there anyone who is not? No. Okay.
Okay.
Leslie's going to work with you going forward.
Yes, yes.
I don't know if everybody's aware, we've worked with Victor Chang for many, many years. Victor retired.
Oh, good for him.
Oh,
He was older than I thought. I go, how old are you? He goes, I'm 65. I go, well, you aged well, But everybody knows Leslie, she was always with,
Yeah, she
always did all the numbers.
The heavy lifting.
So she's now taking over Victor's
Yes, and then she's
position,
got it on her
at least for
back.
Will County.
Well, and I'm not sure anyone's aware, because we didn't make a big deal out of it, but the $175 million issuance, Leslie was the lead at
Leslie
Wells.
did the-
Rashawn and I did it for the county, and Rafaelita did it for Spear Financial, so it was almost all women-led.
That's
And
right.
that's a
right.
big bond issuance.
All right.
That's big, so.
That was big.
Well, you're right. Leslie has been doing it.
Yes.
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 And so we'll look forward to seeing more of her going forward.
Yes.
Yeah.
Thank you. That was it?
That's it, thank you very much.
Thank you very much. All right. Okay. Was there any other old business? Nope, think not. All right. Okay, moving into the new business, the governance rules and procedures for the board. I know that we did have some items that came forward today, some glitch in the system, and some of them may or may not, Mary, need the review. You can speak to that.
Well, that's, I don't know that they need the legal review, but I expect that the committee would want to discuss whether or not those changes are something they're on board with.
Okay. Thank you. All righty.
Denise, I thought in our last conversation, you were taking that 103C out.
Yes.
It is out.
Yes.
It's
Okay, what do I?
That's not
Red
in
line.
that packet. I'm sorry.
I got too
Yeah,
many
you're-
back.
What I have now is red line. Yeah, I've got a number.
Yeah,
Mine wouldn't come up on the computer or something.
okay.
Mine never comes up under the portal. I just,
We don't have the new, we don't have this. We just have to
Okay. Question?
Well, the first general question I would have is, Mary, are any of these changes your recommendation?
I know.
I know there might have some words, there's been just a couple words changed. I don't know if they came from you, or if there's just additional cleanup. First, I want to know if anything came from, as your recommendation.
We're talking general right at the minute.
Right.
Not on a particular one.
No, not a particular one. I'm just want to know if anything in here was recommended by you.
So, in what is attached, I did make a recommendation, and I'm trying to refresh my own memory, with regard to, I did add on page 21, 3.06B, the limitation on public comment was 2 minutes. I suggested that that
Okay.
be qualified, because there will be issues that come before the town board
that will need more than 2 minutes.
Point of information,
The presiding officer.
Okay.
Wait a minute, Don.
Are we looking at-
Wait a minute, Don. Were you done, Mary?
Yes.
Yes,
Okay.
okay, so that was,
Thank you.
I need to know, are we looking at 2A or are we looking at 2B? What are we supposed to be looking at right now?
And which attachment?
2A is the most current. That was with the changes that came out of the Democratic caucus on Monday night.
Thank you.
yeah. So,
Okay, I'm not sure that people are clear which one. So the one that you are referring to in the upper right-hand corner says 5.2A?
Correct.
Okay.
The file should say draft down proposed.
Thank you.
I think I got it.
Was that helpful? Yes. Go ahead, Maura.
The rule that Mary is citing is 3.06, right to address the board in public comment. Under that, it is Part B, where Mary suggested adding unless waived by presiding officer.
Wait, I thought that was crossed out.
that's what I'm asking.
What
It's
page
in
is
there.
it on now?
Page 21.
It's page 21 on the document 5.2A in the upper.
This has been crossed out.
Out of section 4, because that
It,
doesn't
it was redundant in section 4.
added to
Okay,
address
so it's,
all
all
rights.
right, I see.
So at this point then, for clarification, under 4B, or no, B is not under 4, it's under the initial 3.06. B has been added, and it says any permitted public comment should be held to less than 2 minutes unless waived by the presiding official.
And that came from the state's attorney's
His
office.
office, right, and that's a suggestion from the state's attorney's office. So in the case where we need to talk longer, for instance, we may have some authority on a particular item. I'll just use as an example, it might be, I'll just use waste management as an example, if it were Chuck Helston, for example, who came forward to speak. That reasonably would be more than 2 minutes, or could be, just based on the complexity of the issue. So that might be an example of where whoever's presiding might waive that question.
Okay, the only other question I would have on that, and the reason I asked for yours first, Mary, is because it's easier to discuss you first, I think, or your recommendations first. It says unless waived by the presiding officer. Now, in this case, our presiding officer is not a member of the board. He presides over the meeting. Technically, the presiding officer cannot even participate in our meeting because he's not a member. So the board would be giving up its right, so to speak, or giving that authority to a presiding officer or to a non-member of the board. My preference is that it would go to county board leadership on the floor to waive it. But I'm just throwing this out so the board is aware of, presiding officer basically has the authority the board gives him. I mean, or her, whoever the case may be at the time. So I want to get your view of, or do we agree that the presiding officer under the executive form of government is not a member of the board and cannot participate or make a decision for the board unless the board grants him that ability?
So
I'm just asking that. I mean, would we be giving up the authority of the board to the presiding officer?
I think the statute gives the county executive the authority to preside over the county board meeting.
Correct.
And inherent in that is some decision-making with regard to the actual running of the
management of the
But the
meeting.
2-minute rule is a county board rule. It's not a statutorial rule. I mean, so my point is that the rule is a county board rule. And if the board wants to give that authority to the presiding officer, that's fine. My experience has been is that over a number of presiding officers in the county board meeting, they do not enforce the 2-minute rule ever. And it gets a little frustrating, I think, sometimes on the board. From a board member perspective, I think sometimes that gets a little frustrating. But then the board member would have to intercede and make, point of order saying they've exceeded their time. So I agree with this, that there should be a limit. But since the presiding officer, I'm just pointing out that the presiding officer is not a member of the board. It's a board rule. The board can do what it wants, but I'm just pointing that out, Denise, that's all.
Right, I understand that. So for you then, it would make more sense to say unless waived by the presiding officer at the discretion of the board.
Yeah, yes, something along that line.
Or upon a motion to suspend the rules and allow.
Yes.
Would be.
There you go.
We'd have to
There we
suspend the
go.
rules.
That would be better. Thank you, Mary.
Could you add that, Mary, in there?
So-
Okay.
Is that acceptable to everybody here?
Yes.
Okay, thank you. Okay. Mary? You had some others?
I think that was the only one.
That was the only one for you?
that highlighted that was.
That was yours? Okay. Did I,
What page these things are.
okay. The new ones? Okay. Okay. Steve?
Does that apply, the 2-minute rule apply to committees?
No, this would be at the board, at the full board, public.
Public comment.
Legally, according to open meetings, you have to have a rule for committee meetings.
Okay, that would be separate from this one. I hear what you're saying, Steve, but that's separate from this one.
It's in here, Steve.
Yeah, this is just for the public comments piece. Right. Okay. Okay, more, you take us to the next one.
Starting at the top now?
Yes,
You want to start back at the top?
please.
So then, I believe it's in your packet, the 5.2A copy in the right-hand corner. It would be Rule 1.03B. On my copy, it's page 4. Is everyone there?
So you're on page 4.
Yes.
Again, Rule 1.03B.
Got it, Jim?
Still trying to get there.
Jim, you want to,
Why don't we have
Okay, got it.
would it be easier with a hard copy?
I do have a hard copy here.
Well, this is in color, so if you want that, that's where she's at, 1.03B.
Nice to like what the state legislature did. On the left-hand side of the margin.
So,
Would be nice, we do that in NACO too. That would be helpful.
Just put it up on the big screen.
Yeah, that would be nice. Yeah.
so
Okay, so we can do that for the county board. Go ahead, Maureen.
Part
Sorry.
B reads, the second line on Part B, all staff of the board shall serve the county board members at the discretion of the county board speaker. That is how that sentence,
Directions.
I apologize, I missed that word. All staff of the board shall serve the county board members at the direction of the county board speaker. That is the proposed change.
Can I just, really, most of my stuff is, I'm going to ask is probably just to clarify, exactly what does that mean? Okay, currently, the county board members have access to the staff. They can ask them questions. They can ask them to do something, and so forth. Well, let me just explain how I used to do it, maybe. And so, everybody had access. I would say, you can go to staff, you can ask them questions, you can go to more, you can go to
And this doesn't
Melissa, you
change
go to
that.
Beth, and all that, and if there's something that they felt uncomfortable with, I would say then come to me. If it's something you feel uncomfortable with.
Right.
And I'll speak to the board members.
Denise.
So none of that changes.
Right. None of it changed.
None of it changed, and actually, Jim, this is to clarify that point, which just simply then, it's now in the rules that a board member can come to staff with simple questions, and as long as, if it is complicated or something that is more, not ready in nature to be given out to the entire board, then it would go to Denise, and she would then take the question or the issue up.
Yeah, okay.
So people just wanted to make sure that they had the ability.
Exactly what you said.
Yes.
Yes, exactly.
Okay.
Just codifying.
Okay, very good.
Everybody okay on that one?
Yeah.
Okay, so then the next suggested change would be, Part C, that was a suggested change, would be taken out. So that will not exist at all as Part C on this set of rules that would be voted on. Correct, Denise?
Right, and that's what I understand from, in talking with the leadership team, yes.
I do, though, have a question to ask. Because, some things have just been practice, and it hasn't been in the rules. I'm specifically going to talk about county board staff. With the exception of the chief of staff. And the chief of staff is different because the chief of staff deals both with policy and day-to-day administration. I always looked at the chief of staff who really had overall operational authority over the staff. I mean, on a day-to-day basis. How they split it up, I never got involved. If I'll go back to Bruce. If Bruce said, well, Beth's going to be responsible for this, okay, he would tell me. And he may not have been day-to-day because Beth did that, but the chief of staff kind of said who's going to be responsible for what. Of course, the exception to that would be our budget director, who basically is separate and is on kind of an equal footing with the chief of staff, but they work on budgetary things. So the rest of the staff, and let me say that there's political implications to the chief of staff. Certainly, chief of staff serves as at the pleasure of the speaker and the majority party. So I understand, but everyone else, I want to make it clear, everyone else there is a regular employee.
Right.
And I see Mr. Tidwell there, and you can ask Bruce. I always went through HR. I never even interviewed people.
Right.
I let HR do it, and then the staff did it, and then the staff made a recommendation.
Right,
So I want to
and that's not changed.
So I just want to make it clear whether we need to, and I don't think we need to put it in here, but I followed the personnel policy that's in place for the executive's office, which we set. So I guess I just want to make it clear, I want to make sure that, with the exception of the chief of staff, that all our other employees are regular employees who have all the protections that all other employees have. That they're general employees. And so, all those positions either came in, transferred in from another area, but they've always been posted. Bruce always put it together.
Right.
I didn't even do the interviewing. I didn't do the selection. I let the staff, and I let Bruce do that. And then I let them make a recommendation who they thought would be the best person. So, I don't know if we need to, and Mary, I'm gonna look at you. Do we need to say that? Because to me, it's like, that's what it is.
Yeah.
But I don't need to say it.
Request at the Democratic caucus that I draft something to reflect what the current practice is, and that it be codified. So I will be working on that, and then there can be a vote in the future if you want to add that or not.
In the absence of that, I guess what I want to say is that they're employees. They have the same rules, the same protections of any other employee. You can't just come and say, they're non-union, And I think I want to make a distinction, Mary, between an employee who's non-union and an exempt employee, because I do think there's a difference. The chief of staff would be an exempt employee. You know, just because you're non-union doesn't mean you're an exempt employee.
Right.
Correct?
Correct.
So they have all the protections of any other employee.
Right.
They are protected under the Fair Labor Standards Act. So
Exactly.
there is no overtime or anything like that, and they are protected in that sense.
So I would say to my Democratic colleagues, if this was a subject for your caucus, I just want to say that, you know, we follow the law, we follow the labor laws, and we follow the personnel policy of Will County, or the personnel policy that basically applies to the executive's office, since that's basically our personnel policy.
Right.
And Bruce, you might maybe to say, that's how it's always been?
That is how it's always been.
You know.
And that's how it's going forward.
Right. Every job's been posted and so forth. You know, regular people shouldn't be subject to, you know,
Right.
they should be treated fairly.
And you're exactly right. And it was a proposal by one of our members. Discussion brought out that it's not a necessary thing. And in talking with Mike, we all agreed, we don't need that.
86.
The regular.
It doesn't support what our practice is or what our intent is in terms of working here, so, yeah.
Any more discussion
Yeah.
on that? Okay. The next change is on page 6 of my copy. It's Rule 1.05, under Section A, at the bottom of the page, number 1. And I'll just give you a little background. There was discussion had by, I think, a lot of members about moving the budget process up. And as a response to that, the rule now will say, for A1, said budget shall be submitted by the county executive to the county board at the regular August Will County Board meeting. Okay, and then the relationship will then flip the process, which you will see on the next rule change on the following page, page 7, B1, where it says, "The Will County Board hereby designates the regular September county board meeting for the making of the county executive's annual report to the board."
And yours may say July, but it should say September.
Yeah, I'm just, why are we flipping that? I mean, I understand August for the budget. Why
Well,
are we going to
then,
do the state of the county after the budget instead of?
well, then the new budget information would have been incorporated.
Yeah, you know, I may be the only one was here, you know, Mary, I'm going to ask you to weigh in on this, because, you know, the state of the county and the budget were done on the same day. For some reason, I'm thinking there was some reference in the state statutes to that.
Yeah, one of them has to happen in August.
You know, so, you know, they can be in the same day, at the same board meeting, which we did do for years. And then it was requested, I don't know if it started with your administration or not, Nick. I mean, I don't know if having the Mike in administration, that we separated them, or, I don't know when we did it. It was an accommodation that was requested by the county executive, whoever it was at the time. And I don't know if it was meant to be a permanent accommodation. I think that there was a reason maybe we did it at that time. But I want to point out that basically the statute says that both will occur in the same day. And it is an option.
Mary's checking the statute, if it says the same day or that one of them has to happen in August.
It has to be the same day, but I do
Or maybe-
think that the state of the county report has to be in August.
At the annual meeting, I thought, and that
Yes, which is,
Okay.
Which is the first one before we go to the
I
recess
knew there was
meeting.
something in there, but I'm just saying, for many, many years, it was the same day.
Okay, so
Okay,
you're
so-
fine.
If
While
we-
she's looking that up,
If we
Mike.
are going to do the budget in August, and then the state of the county is going to include budget information, it makes more sense to do them together.
Well, that's
The way
why.
we were doing it now, it kind of makes sense to do, you're doing the state first, and then you were doing the budget, but if we're gonna already have the budget information, why can't you just do them both together?
That's why we did it together. There was a reason that
Well,
one year...
Mary checked the statute.
And just, Denise, if I could make one more comment.
Yes.
Prior to now, I think there was some projections made because, as I'm sure it can be explained a little bit better by Melissa, but, right, because of, you don't know for sure until October.
We set the estimate of the aggregate levy in October, so it's all estimates at that time.
Okay,
Projections, estimates.
okay. Nick, something to add?
Just a ball.
Obviously, the state law drives all this, so if whatever the state law says, and I don't have it committed to memory, but I believe it says reference to giving an annual report on the state of the county. I didn't recall if it said which month, but when this was discussed with a few individual board members, rather than, if we're going to do it in separate months, we thought it might make more sense to do it in September. We meet 12 months of the year, theoretically, so it doesn't matter what month it is, but one argument could be the budget, when we present it, is going to be even more tentative when we're presenting a month earlier, but it gives the board an extra month, and that was discussed throughout the fall. We talked about giving more time for the board to review it. So it's going to be a little more fluid, but it gives us more time to dig into departments and things at the county board level, because Rashawn is dealing with the departments throughout the year, and it was getting earlier. But there's an argument maybe to be made that if you give the budget address in August, now you've got numbers to kind of work with. The state of the county has been more budget and programmatic stuff, so it could kind of, here's the numbers, here's what we're going to work with, and in September, you spend a separate meeting talking about what those dollars are going to drive, and now you've had a month to look at the numbers, so it may make a little more meaning. And because I think our meetings sometimes do go longer, and it just, putting it all in one meeting may be a lot to cover, but I mean,
part of the reason
but it's been done both ways since the current county executive's been here. We've done it separately, and for a few years, we did them, it was one address, not two addresses, but then it went back to two addresses, one for the budget and one for the, and the budget address, for those who haven't been here, is generally much shorter. The state of the county has fluctuated, but it's a little longer than the budget address, because the budget address is basically, here's the numbers, here's the book, we'll get into it in committees.
And it makes a big difference in this.
Right.
I mean, because the budget is basically like, say, here's the budget, look it over.
Right.
No, I mean, it'll be things that we think it's balanced or whatever.
Yeah.
Okay, thank you. Yeah, okay. Mary, is there any requirements?
The only requirement is that the county executive prepare a report set in the month that the county will determine.
Okay, so we could do it that way. Okay, okay. Is there any resistance to this change?
Okay, well, I'm just going to ask, does this set 2 meetings?
Yeah.
Yeah.
This put, in the rules, puts it as 2 meetings.
Right.
I think the board should leave some flexibility for themselves, whether you want to do it in one report, in one meeting, or you want to do it in 2. I'm just letting you know that it doesn't have to be 2 separate meetings.
Right.
And the budget, basically, here it is. I mean, it's not like it's a lengthy meeting.
Right.
I'm just saying that, do you want to
Thank you, Maura. We could say August or September. What you may want to remember is, because we do have a lot of new people at the August meeting, I would imagine that even though here's the budget, here it is, there will be a slew of questions which would lengthen the meeting. So maybe we can do August or September, and then that way we can separate them if we think that we need to. There may be some contentious items, some questionable items that require more discussion on the first pass, and that gives us some time then to come back with the state of the county separately from that. Tyler?
My question would be, based off of what you said, don't we have to set a definite meeting?
It's important that the county executive knows what month she's going to be presenting presenting it.
What Nick's gonna do is that.
My concern is who's going to communicate that and when,
Okay,
if you leave it open.
okay. So then we do need to make a commitment one way or the other. Suggestion,
So,
Mike?
here's my thought. We obviously want to do budget a month earlier. It gives the board a lot more
Right.
time. I personally think if he gives the budget address and then goes right into the state of the county, it may make more sense hearing the numbers and the address. If we wait a month, you kind of forget what was said. We don't, and I don't know, in the 6 years I've been here, we've never asked any questions of the executive at the budget address. That is just for him to give an address. We haven't asked questions. So it's not like there's going to be a lot of questions there. But if all that information is given in one nice package, then they could see, what he's saying about where we're at and why the budget reflects this all at the same time. So I would say August, but both together.
Okay, so what's the pleasure of the group?
I like August.
Don's got a question.
Oh, Don, sorry, didn't see it.
Given that the county executive is statutorily required to give an annual report to the board, why do we care when it is? Why do we need to have it in our rules? He's required to give us that report. Let him give us that report.
We have to set when he gives it.
We set the
County board sets the date.
We have to tell him when.
It's our job.
Doing it toward the end of the fiscal year because then.
You have more of the numbers in.
Understand the needs of the county when you're deciding on the budget.
Okay, then.
It's in state statute.
Okay, so given that we have to tell him when, what's the will of this group? All together, August. So those who are for one meeting, let's see a show of hands. Well, that seems to be a majority. Okay, so then, do we need Mary, do we need a motion for that? Okay, so then, I need a motion then to put that in the rules, that it will be the one meeting in
Motion.
August.
Second.
Those in favor? Aye. Opposed? Okay, Maura.
So then, I will have August in both of those rules then?
Right.
Okay.
Okay, what's next?
The next change, and Madam Speaker, did you want to go over the changes we received just prior to this meeting?
One of them does,
Okay.
one of
All
them
right.
is tied to one of the things that's already in here, so maybe you can pick that up at that time, and then we can go back to anything else.
Okay, so the next one is just on the next page, page 8, and there was some discussion about number 4 on page 8. It's under,
D?
yes, it's 4D. I was just getting the rule. It's under the 1.05 rule, but it's on page 8, number 4D. And it says appointee qualifications, and then in parentheses added to that, it will say upon request, resume if applicable. So there are some bigger boards where at times people have requested to see resumes, and I believe, those, if asked for and they exist, will be provided to board members on a case-by-case basis. Is that fair to say, Madam Speaker?
Yes, and for some of our boards, they're appointed, they may have like only $500 a year. Some of the bigger ones may have like around 20 or so thousand a year, which is not a fortune, but in terms of a board appointment, it could be. And so for those, people want to see more of the qualifications, why this person was
So like
chosen, what the
Metro.
background, exactly, Metro, RTA, those boards, what's the background of the person that's being proposed for an appointment. So in those cases then, the resumes would be a part of the package for board members to be able to review beforehand, so that when they're voting about whether or not they want that person, they have a full background on that proposal. Question.
I was going to say, one of our items has additions to this as well, so we're going to do that now.
That's what I was asking. So I think we'll go through these initially, or unless
Okay, and I had a question down here.
tie it in now. Well, Denise, what would you, some people are asking to
Okay.
tie it in now. What do you think?
Okay, so what is more convenient for this board? Maybe it is going to be easier if
Okay,
you just
I
tie
can
it
do
in
that.
now. Did you have a different question, Jim?
I have a question, only, here again, I guess I'll look at you, Mary, on this, is, some of our boards, such as Historical Society, whatever, even Stormwater Management, those are like internal Will County boards or commissions. The ones that come from like the state, like Metra, RTA, Tollway Authority, I don't know if we see Tollway Authority, but
Bigger boards.
Those rules and qualifications are basically set by the state of Illinois, correct?
Right, they set the rules. We were just asking to see the information.
Well, I'm just wondering if it's not something that the, like state aid or the state doesn't require, can we require something above and beyond what the state is requiring?
I would think no.
So if the state doesn't require a resume, then the state don't require a resume. I mean, usually when you look at these applications, it'll ask for experience, it'll ask for different things, but it usually doesn't say, submit your resume. It could be, even the Joliet, I don't know about the Joliet, like Port Authority, we have
The state, I'm not an expert on the state process, but the state has an online application similar to what we have, and I don't recall how deep they go. But I guess is your question, if there's state, all the names we bring forward hopefully have met any requirement from the state or whatever. Like in Pace's case, you have to be a mayor or a former mayor. Those are the only people that are eligible to serve on the Pace board. That's the law. So those are the only people we can bring forward.
I guess I'm saying if they don't require a resume, Nick, then there's no resume requirement.
And that's why it says only if applicable.
Only if applicable.
The danger is...
Because in the sense where they don't require, we are certainly not going to be asking for something that's not already in the statute.
It's almost, and I don't want to belabor this point, but it's almost like, this is like it depends. I think you really need to say, these appointments, we require a full-blown application, whereas like the one that I think is a little bit just cumbersome is like when we have county board members who are getting appointed, do we need to have them fill out the whole form and the resume or whatever? I don't know. Maybe you guys want to see what everybody's background is. Maybe that's helpful. Or is it just like we know who Mark Ferry is, so he can be appointed to the Stormwater Board, It's like, but there's other ones, like cemetery districts, I don't think you guys want to see all their background on that.
And I think...
Mosquito abatement districts, I'd prefer we don't make those appointments.
This was just to address because there had been some requests to see resumes if they had them, if they had been turned in, and those are kept, obviously, for HR purposes. You don't give them out in droves.
That's been more for hiring than for boards and commissions. The boards and commissions, we came up with a form, I forget how many years ago, but that's the form that you see. We've continued to try to open the process up. We put all the boards and commissions online. We put the statutory references, so if you have an interest, you can go research it yourself. We've tried to put what the qualifications are, what the makeup is. We've tried to put if they get compensation. There's very few that get compensation from Will County, but the state ones, some of those do have compensation.
I guess my other concern is this, over the years, I've had to intercede with the many county board members to say, that's not your job, right? It's not your job to go digging through HR files or whatever. You can ask some questions, whatever. I don't think that, and I'm talking about now Will County commissions, whatever they may be. Some may be there by law. For example, like ESTV board, it says, you will appoint these people. Here are the people you'll appoint. You can set up the makeup of the board. And usually those are emergency management people, somebody from administration, and usually somebody from the county board. My concern is that board members selectively, or start going, say, well, I want to see this person's resume.
Yeah.
If we don't require it now, getting back to applicable, I think there should be a clear understanding. We don't require it. Also, getting back to your thing about county board members, if there's boards or commissions that require a county board member be appointed, like the health department, says there will be a county board member. If there's so many population, you get 2 or whatever. No, I don't think the county board member needs to give you a full-blown application. It requires a county board member to be appointed. That is something that,
Those generally have come through.
Leadership and administration works out, right?
Yeah.
I just want to point that out.
Right. I'm thinking more like the Stormwater Committee, which it can be a county board member, or it can be someone from your district. And many board members have either served or found someone from their district to fill those, because we still have a few vacancies, I
Do I
think.
think a county board member needs to fill a resume out to go on the stormwater management?
That's what but
The answer is no, Nick.
But the rules say that, and we've had people question us, why aren't you submitting an application?
What rule is that now? Whose rule is that? That's county board rule?
I believe it.
I don't recall. Maybe you could just bring it to the
I'll look and
committee
see.
later.
Yeah.
I think you
So,
should take a look.
I'm
It's
listening to
happened.
the discussion here. It sounds like the right thing is to leave 4D as it stands without the parenthetical comment about requests, resumes, if applicable.
think so. I
It
think
seems
so.
like that's appropriate. And I will say this, that we do not want to ever be in the position of usurping the HR function. That is not our role as the county board. Certainly was not the intent of this. So for whoever would have thought that we want to have more control over that, I want to see this, I want to see that, that's not appropriate.
It's not our job. Right. Okay. I'll make a motion that we remove that, upon request resumes, if applicable, be removed.
Thank you. Second? In favor?
Aye.
Any opposed? Thank you.
So you won't see the changes are in the same section there. They don't exist as current, but I do believe a copy was passed out to everyone of some additional changes that were submitted by the other Republican caucus. And it would add an H and an I to that number 4. And the H would read...
Whoa, wait a minute.
It's not.
It's not, you won't see it on there, it was handed out. Everyone has...
Okay, all right.
I'm sorry, Maura, which number 4?
Same number 4 on page 8.
Number 3 on that sheet.
Number 3 on the sheet. Okay, got it.
And H would read compensation of position, so that would be a requirement then for information contained on the possible position that would be appointed. And I don't know if you want to talk about the proposed H separately from the proposed I, but proposed I would say a list of other positions that you are appointed to by the Will County Executive. And I believe, and I just want to clarify that means if you are applying to be appointed to something and you are already serving on a committee or already appointed to something, that you would have to list what else you currently are serving on. Is that?
Yes, the concept.
Is that what you're after?
Yeah, the concept behind it, we just don't know what the compensation is of that appointment, and if there are other appointments that you've already been appointed to.
Okay.
So if the person's been appointed to 3 different things, we want to know it. If the person's been appointed to 3 other things, we want to know what other appointments do you have?
Deputy is part of the application.
So we currently furnish the information about the compensation for each of the positions when we say these appointments are coming up, and she puts that out there, so you need to get more than that.
Well, I thought it was not always on there.
So it didn't used to be, and this
We have
board
been
asked
recently.
for it, and so
Okay.
now...
rules, that's all.
Yeah.
So this board asked for it, and so now it is. When she says, this position is up for appointment, the compensation, whether it's yearly, monthly, or whatever, is on there. The other thing is, so, yes, the staff does provide that. So, that is now...
We've been getting,
But it's not in our rules.
It's not in the rules. So if you, so you're asking for it just in the rules to say that it will always be
So it's-
provided?
yeah. Since we get it anyway, just put it there because we asked for it.
And the other one is, for example, if I'm appointed to a position, how many other positions am I appointed
Appointments,
to?
right.
How many other positions have I
I
been
have a
appointed
question on
to?
I.
Yeah, I want to take some exception with that, by the way. And the exception is county board members. many county board members wind up on more than one thing. You know, I mean,
Absolutely.
this idea.
It's just the nature of the work.
Is it, you know, so I would exclude county board members. I mean, you just say, you know, I mean, we kind of know who's appointed to what, but, you know, I mean, I was probably at one time on a half a dozen. You know, some of them by rule, you know. I mean, I was on,
I'm like workforce and CD, but not through the county.
workforce, I was on,
So,
I want to say HUD, but what is it? CDBG. I was on CDBG. I was on, and some of that was required as my position as a county board member. You know, like on CDBG, I was on workforce, I was at the Public Billing Commission, you know. So, we have board members on the Health Department, maybe at workforce. So, you know, I don't know if that should apply to county board.
Why is it not good for us to know that? I mean, not everybody always knows what boards everybody's on.
I'd say that, I'd
You know,
ask
because you know
this
that.
I guess I'm
question.
wondering, hold on a minute.
What's the
Why
point?
you need to codify that, because that's flexible at any given time based on the thing. If there are people outside the county board, and this is just my own thought on this, if there are people outside the county board who are appointed to multiple positions, that's one thing. But for county board members, I would have to say, the nature of the position or the district, it may be that a
part of our
particular
job.
area or region is required, but that is the nature of the work. The work is that as a county board member, you are responsible for certain boards, certain positions, whatever. So that's
Well, and
it, done.
It could say appointed required next to it, so you know that's a
So then you
requirement of
have
the
to list
position.
it.
Here's why I'm not comfortable with I, because you might have people that either if they're on the county board or some other board, whatever, the county executive appoints somebody to something, that doesn't really give you the picture. I sit on a CED and I sit on a workforce investment board, neither one of which is on behalf of the county. Okay,
That's not what we're asking for.
I understand
Only
that.
accounted
but-
by the county board.
So what's the point? Because I serve on 2 other committees, somebody else that was appointed by the county executive sit on 2 committees. You know about them, but you don't know about me, so what's the point?
Yeah,
Because it's an appointment.
So what?
yeah. Nick?
I'm looking at the online application, which I'm going to check to make sure this is 100% reflected. We have a hard copy of this too, but it asks basic contact information. It asks if you're an elected official, if you are, what office, current employment with titles and duties, which I don't know why we don't need to know that, civic activities, list of current or previous boards and commissions, and professional organizations. And it asks, have you ever been employed or held office with any state or local government? If yes, explain. So that's all on the application right now.
Oh, really?
Whether everybody fills all that out, or they just put NA, we don't do a background check on people to make sure they're telling the truth, but we ask for references too, so that people know kind of where they're coming from. And if you don't know the person, but you know one of their references, you can call them and say, hey, do you know Bob, or do you know Mary? Would they be a good fit for our Workforce Investment Board, or, you know?
Or maybe we just separate the question on the application, says current boards you're serving on.
Yeah.
Well, it's current or previous, so.
Yeah, current or previous. Judy has a question?
So, no, just a comment. So the point of listing the other positions appointed by the county executive is just to know if one individual that we're appointing to multiple boards, we appoint, doesn't matter if Don serves on 2 boards, he would list in that other section, but if we appoint to those boards, and we've appointed him to that board, and he's appointed to this board and that board, the point is for us to understand that Don has been appointed to 6 boards, and Ken isn't, and he would like to be, so maybe we could
Spread the wealth.
have that up. Well, I think everyone should have that right, versus one person being in the room maybe, or whatever the consequences was of him getting all the appointments, and Ken wasn't. I think it's fair to distribute, rather than have one person have a lot of power by being on multiple boards, that we appoint.
So some boards, by the nature of their setup, require particular positions from the county to serve on those boards. So are you asking then that all positions not covered by requirement then be spread?
No.
Because there is a requirement on some of the boards.
Some are required, sure.
So,
Some are required, we
That a
have
particular person,
to.
I see you.
Like
That some of
CED
the-
wants leadership,
Yeah,
right?
right. So are you asking beyond that position then, if there are other slots, if there are multiple slots on a board?
Well, even
beyond
if they're required, in my opinion, if they're required, that we have, say, a mayor, I think that we should not always choose, say Jackie's the mayor, she's the mayor next to me right now. If she's the mayor, I don't think she should
Maybe a
be the
mayor.
only one who's on there, because Ken is also a mayor, and I would want to give him the opportunity of serving on a board rather than choosing Jackie a second time. So I would like to know that.
Okay, but you wouldn't be the one giving those opportunities, it would be the county executive.
But if it's on the application.
Right, but it
Yes,
comes through.
and it's on the application,
Yes, he
yeah.
does, but we can deny it then, right? We can say, well, no, we would rather have, because we can put up somebody else.
And you can't do that now. I see Tyler and then Don.
Somebody's gonna have to turn off their mic. My question is, since we get a list of all county executive appointments in December, I think we just got it, isn't this already covered? Because, I mean, we have, I looked at it, we got the list of it. Yeah, but you have the list to compare it to. Yeah, didn't, I thought, wasn't that the list that?
Yes. And by your rules, the county executive is required to turn that over to you at the beginning of each year.
Right?
Yeah.
I just want to make sure I'm not missing something.
No, you're right on, Tyler. Don?
Couldn't we solve this same problem by just asking who all applied for the position? Because in a lot of cases, there's only one person that exhibits any interest in participating. And that's why they get appointed to a lot of boards. Maybe they've got more free time, more energy, more knowledge on certain
Or it's a
subjects.
fit.
And if we knew these three people applied for the position, then you'd have a better idea of what was going on than you would if
yes.
the county executive appointed one person to 5 different committees.
Julie?
Okay, I have one question now and a comment. First, my question is where and how does a board member get the opportunity to indicate that the position is available and to express an interest? Because I'm not aware of that.
That's the list.
My comment is that I think I is important because if you find that the appointments are unbalanced, and let's say somebody is appointed and they're already on 3 committees and has 2 other appointments, perhaps you should give the opportunity to someone who hasn't had that opportunity.
Maybe we should give the opportunity.
Okay. Nick?
Just to reiterate, and I've said this before, but I'm going to say it because I think it's important. Number one, per the existing rules or previously adopted rules, we are required to submit to the board a list of all the appointments for the coming year. So that way you have a list of all the coming year so that are expected. There's always people who resign during the year, and those are new. But several years, many years back now, we created an online database so you can see every appointment we make, every person who's in that spot currently, 24/7, 365. You can go on there. And as far as application, we have taken letters of interest all the time. If we don't have an existing vacancy, we keep them on file. But on our online process, it's under the county executives page, you can nominate yourself or nominate somebody else, and you can pick which board or commission. So you could apply for them all if you want. Now, the fact is, there are boards like the cemetery districts, the drainage districts. If we can just find somebody who's willing to show up at a meeting, it's a victory.
It's a big deal.
I mean, as we're sitting here, I'm thinking, I'm going to group all these by those kind of appointments, and then the ones that probably you really care about that are like the RTA, the PACE, the Metra, the ones. The tollway is the governor makes those appointments, not the county.
Yeah, that's not on us.
But the workforce, but I'll also say, because I think this is worth saying, we have made a conscious effort, we as a county, to diversify our boards. I mean, we've not been completely successful. There's still a need for more diversity in our boards, but like our Workforce Investment Board, by law, is required to be 51% or greater business. We've tried to go well beyond that and get all reaches of the county, all areas of the county. But the other ones, like the Planning and Zoning Commission, that's spelled out by the rules of the law, specifically what areas they have to come from, and there's only there's a limit on how many from which area. So, and if any board member has a question or an interest or has a constituent that's interested, come talk to us and we'll see if there's an opportunity. If it's not a county commission, maybe there's some state commission we could recommend them for and push, because there are a number of state commissions too. But they've been a lot, but the last thing I'll say is Will County, I believe, hasn't done this, but DuPage County helped pass a law that gave them the ability to take some action on their own to get greater accountability of their boards and commissions, because they had some issues. So there is possibly some additional action. I don't know that you want to go down that road, but I know DuPage had some issues at some of their boards and commissions. They had like 20 mosquito abatement districts, and they were doing like 16 different contracts, or maybe more than that. We only have like 1 or 2, so, but we're glad to talk about that offline from this meeting. So.
Thank you, Nick. We've had quite a bit of discussion. I'm going to bring it back to more.
So just to be clear, currently, you have to go through and fill out the online form or the paper hard copy, and it does ask you whether you are currently on a board, what you serve on. It does not contain the information about how much money you will make, if any, on the board, so that would be an addition, correct, Nick?
It doesn't ask if you're being compensated for other boards.
Oh, but
on our website, and I'm not going to say it's perfect, because if there's a correction, please let us know. But on our website, we do list whether positions are compensated or not. And I know the board office double checks that to make sure, because that's been a request in the past. But it's on the website.
Okay, so H would contemplate adding to this rule that it would be necessary to list the compensation of the position.
We already do that.
We already give that information. It's not listed in our rules, but we already give that information. So I would suggest there's really not a value to adding H or even I, given what's already available to people if they want to check the information. But we would need a resolution to leave those off. They're not on. Okay, so we would need what, Mary? We don't need anything. I would suggest that we ignore those. That would be my own thought, but I don't know. What is the will of this board?
Someone would have to make a motion to place it on if they want it. Okay.
No motion, okay.
Move on.
Okay. So then we'll leave H and I out. Okay.
Okay. The next change, and I just, is a grammatical change put forth and caught, thank you, I believe it was Judy or Mike, by the, on page 10, it should be a possessive in number 8, where it says, general administration appointments shall be based solely on a candidate's. There should be a apostrophe there, so that will be added unless there's any discussion on it.
Please, no discussion. No discussion.
More?
Okay.
Continue.
Then, also another grammatical change, page 12, under 2.03, standing committees, section C, part 5, or Roman numeral V. It's simply changing in the third line the word hearings to and hearings, just a grammatical change. So if no discussion, I'll move on. Page 12, yeah. The next, which will not be on your paper as a change, but it is number 5 on the handout. On page 15 of your rules, number 5, part 3, currently it reads, identifying the changing needs of Will County's aging and disabled population. It was suggested that we also include and Sunny Hill Nursing Home to that sentence.
Oh, because they mostly hear from...
Because that's a county-owned facility, county-run facility.
Yeah. I'll second it.
Thank you. All those in favor?
Aye.
Any opposed? Thank you.
So Mary, just to be clear, That's not currently in it. They made a motion and to place it on there, and that's okay then? Okay.
So somebody made a motion to put it.
Add that.
That will be added then. Okay. The next one is on page 19, and I will say this, number 3, under Rule 3.01, currently it reads invocation. The Democratic caucus spoke about it, and their proposed amendment to that was invocation or moment of reflection. And the Republican caucus came with the change this morning to remove the or moment of reflection. So the question is whether or not that section's going to be kept in.
Okay, what's the will of the group?
I just want to point out what was pointed out at our caucus. Somebody went back and looked at the last, I believe it was 12 or 13 meetings, and they pointed out that 7 of the invocations were done by members of the board. And based on our prior discussion about how that looks to the public and how that could potentially expose us, it was mentioned that if a board member could not get a pastor, a imam, whatever, to come in and do an invocation, or somebody canceled at the last minute, rather than have a board member do it, we thought it would be beneficial that we just put in the or moment of reflection so that we could do that in place of allowing a board member to give an invocation. The issue was having a board member do it.
And I can speak to that just a little bit, Denise, if you'd like me to. We want to avoid the potential of any bias. So in that sense, having a board member give the invocation and then possibly taking a vote on something later, and maybe one of the audience members did not participate in the invocation, we want to make sure that the public understands that, we can have a moment of silence or an invocation. And if anyone wants to bring in someone of another faith, great. And if that person cannot make it, though, we would then just have a moment of silence instead of a board member.
And that way we don't have any liability from somebody saying the reason I didn't get what I wanted is because you did this. Right here.
Well, the first person I would look at, as far as liability goes, it would be to Mary. But before I ask Mary about liability, I think it should be taken out. Look, historically and traditionally, we've had invocation, we've had a prayer. You can call it what you want. Quite frankly, and this gets, I guess, to be a little bit more of on I don't want to say emotional side, or how I think people can interpret this. My interpretation is to eliminate prayer. Now, that's my interpretation. I'm not going to debate it or argue with anybody. I'm just telling you that's how I interpret it. I think that there's nothing wrong with a board member doing the invocation. I don't see where it creates any liability, but any of us can do it. I don't care if you want to go through every single county board member and just have a list and say, you're next if you want to do it. That certainly doesn't show any bias. It doesn't mean you have to get into some big religious thing. You just, my thing would always be, hey, God, let us do the right thing. Let me do the right thing, please. I think it sends a different kind of message. I think it's, quite frankly, sends out a message of, and maybe I'm taking a little over the top, but anti-religious, anti-God, whatever you want to put it. If you're a non-believer, be a non-believer. But I think that having I'm going to call it a prayer, to, ask for guidance for us to all to do the right thing, and have the strength to have the right thing is a good thing. So I would not be supportive of the amendment or the change. That's all I'm going to say about that.
Well, I can say that for me, I'll be praying regardless, but for Mary, is there, and this, what comes to my mind is that there's a reason why in the House and the Senate, whatever, they have a chaplain, which is then separate from the members. But I would rather have State's Attorney speak to that issue, if there is one.
As you've indicated, there is nothing wrong with having an invocation. The United States Supreme Court has ruled on that and said legislative bodies may have an invocation, may have a moment of prayer. There is a federal decision out of Michigan where there was a local legislative body where only the members of that local legislative body gave the invocation. And the decision, and I understand the reasoning behind it, was that then gave the appearance that it was the board that was presenting the prayer. It was their views, and there were some additional comments about, requiring the public to, participate, and it just went over the top. That being said, I don't think the occasional invocation given by a county board member when we don't have anyone else crosses that line. I am a little concerned about the number of times where we have had the occasion to do that in the last year, because it is getting to the point where more than half the time that has happened. That being said, I think that if the county board wishes, they can attempt to do some other outreach to make sure that all of the faiths understand that they are welcome to give the invocation and, would be allowed to do so. We certainly have the opportunities available. How you want to express that, I don't know that you need to put in there moment of silence in your rules. If at some point we've reached a point where Mr. Brooks or Ms. Fritz have given the invocation several times and we would just prefer to do a moment of silence instead, we can do that. There's nothing requiring, if you don't have someone to do it, you don't have someone to do it.
Okay.
Or you could even ask a member of the public to do it. So they don't have to be a pastor or a minister.
Or maybe you could help us find a permit. Maybe we could find a...
Well, the pay is fine anyway, so it doesn't matter.
Yeah, a chaplain.
Find the same person to come.
Yeah, And right, and I know that in the past, we have reached out to board members, can you bring somebody? And the issue, what typically comes up is that for many people, because you're coming here, you're here like 10 minutes or so and then go back. For some people, the idea of driving here, doing that, and then going back is overwhelming. Steve, are you adding something different to the conversation?
Yeah, absolutely. I called the Center for Justice, Jay Sekulo's group, and he reviewed with me the Supreme Court ruling that Mary just discussed. And under that ruling, as a county board member, I'm able to stand up. If you call a moment of silence, I can stand up after that and start reading chapters from the Bible.
If you're given the floor. If you are given the floor. If you're given the floor by the presiding officer, which let me just tell you right now, you will not be.
They said that that I could file a lawsuit, which I will, and they will represent me for free. Just so you know.
Thank you.
The better idea in this is real simple. Tell all the board members that, when we get some people, because if you tell one, maybe one person can't get them. If everybody knows to get a pastor or a minister.
And that's what we do now, Steve.
Like Jim said, any faith. But if you don't want to hear the Bible written and heard in my terrible readings, I can't see the letters.
But then you're picking one.
You're not
You're
gonna
going to have it. I will stand up and read for 2 or 3 hours from the Bible. I promise you.
There's somebody behind you who will hear you out. Yeah, because there's somebody right behind you who will take care of that. So, thank you, Steve. Mary, did you?
I don't have anything further. As I said, I mean, I think we could, if you prefer, we can do some more outreach, maybe post on the website that this is available. If you're interested, please notify us, similar to what we do for appointments, and try to open it up a little more.
Maybe we can get more participation. Ken?
And basically, that's what I'm hearing also. If it's the individual, the number of times they're doing it, or if it's the invocation. Like Jim said, Mary said, and even part of what Steve said, I mean, if we want to outreach, I'll offer my service to help outreach.
Thank you. Share that with Lon and Beth, because they have had struggles getting board members to do exactly that. They've reached out, and people either don't do it, or the person they tried to get does not come. I saw Rachel's hand first, and then you.
I just wanted to know, is there currently, not necessarily the rules, but a process that we suggest people keep under a certain time limit? Is that something that
It's usually very brief. Yeah, there's not a time limit because it's very brief. Julie?
Yesterday, I just forwarded a name to Lana and Beth of a pastor who's more than happy to come in as frequently as we need him. He was even available as of yesterday, so.
Thank you. That'll help the process. Lori?
I'm in agreement with Jim. I think we need to get a permanent chaplain. I think maybe that would kind of waylay everything. But as for myself, I did reach out to people. Judy and I
know some people have, but it's
64
very
miles
hard.
round trip for 3 minutes.
Yeah,
and that's an issue.
That's an issue
When
for
you're
people, is
taking
the distance.
When you're taking them away from their duties as the ministers out by us, because the minister for the church that I go to, that's his full-time job. That's a 2 to 3 hour for 2
Right.
minutes.
And that's
So-
been consistently an issue for us. Jim, then Judy.
I was just going to say, it doesn't always have to be a minister. You can get a
be a
deacon
deacon, it could be
to
anybody.
come.
Somebody
There's a lot
who
of different types of people that can come. And quite honestly, if you had a friend that said, I'll come and give an invocation. I mean, it doesn't necessarily have to be somebody from the church, right? I mean, Herb might have he might have a member of his congregation that gives much better invocations than him, right?
Okay. Judy.
So I was just going to make a comment. My understanding of how this process worked was we would rotate through the county board, and the person would say, hey, Tyler, we're looking at your district today or next month. Can you see if you find somebody? But I was only asked one time, that I've been on the board for 6 years now, and I've only been asked one time to find a member from my area.
Okay, Deb.
So in my opinion is, that isn't the point. The point is, I'm sure there's other people from my area that might come, but I've never asked again because I was only asked to look for one time. So that's the difference.
So, regardless of when, so the question though is, do we want to leave it as invocation or invocation and moment of reflection? I'm hearing that there may be some willingness to leave it as invocation with the understanding that we will push for more outreach to get people from a variety of districts, a variety of religions, people who are non-religious to come and speak to the group. Is that true?
Yeah, I think so.
Okay,
And you can
so
always make a motion for a moment of silence
if we don't have somebody present. And we will pay attention to how often members of our body are the ones doing the speaking. Does that satisfy our concern, Mary?
Absolutely.
No, it's not.
All right. So then what else do we need at this point? We need a motion to, motion to leave it as it stands from, to remove the proposed change, I'm sorry.
Remove it.
And you second. All those in favor?
Aye.
Thank you. Maura.
Thank you. And then just down to number 9 on that same section, it will say honorary proclamations, not honorary resolutions.
Make a motion to approve that change.
I'll second it, that's a good change.
Question?
Lana, can you please mark me as a no? There was no request for nays.
I'm sorry. Let's back up because that is appropriate. On the previous resolution, all those against?
Aye.
Any others? Thank you, and thank you, Jackie. Okay. Okay, now we're on to,
We're on to page 25.
One moment, because there was discussion, Mike made the motion to make that change for the moving
Proclamations. Yes, proclamations, and I didn't call the vote on it because I backed up. So on the one for Mike's proclamations versus resolutions, we have a motion and a second. Those in favor?
Aye.
Opposed? Would you?
Yeah, I'm a yes.
Okay.
It wasn't previous roll, I just said yes.
Yeah, we just want to check. Okay. Thank you. Okay, we're on target.
All right, page 25, Rule 4, Roman numeral 4, under purchases and business travel reimbursement, it will be changed to read, board members who wish to attend any conferences, seminars on behalf of the board or that relate directly to board business must contact their respective caucus leader to seek any reimbursement, and then in parentheses, registration fees, travel, parking, etc., period. All requests will be granted only by the speaker as the budget permits if a request is granted. And then it goes on to say, board members will be entitled to business and travel reimbursement consistent with the Will County Business Travel Reimbursement Regulations, which I believe everyone has a copy of.
Right, and that is not different than our current practice. It is just codifying that in here. What we currently do is, as budget permits and as requests come in, we look at those and see if that's something that falls reasonably within the board rules or board needs, and then grant those accordingly.
Motion.
Motion to accept the change. Second. Whatever.
Second.
Those in favor?
Aye.
Any opposed? Thank you.
The only other change that was proposed, that it will not be on your, in your agenda because we received it, it'll be on the handout, proposed by the Republican caucus, was a request for a list of current appointed positions within the county executive office and the county board. So it's not, I'm not certain where that rule would be placed if it were to be put into action.
Not a rule.
Get rid of that.
Okay, it's already been, so skip that?
Yes.
Okay.
Okay.
I believe that's all I have unless anyone saw anything else.
Okay.
Okay, that's all I have with the rules.
Okay, so, given the discussion and what the changes have been made now, we need, I believe, Mary, a resolution to move it forward to the...
Motion to move it.
Motion to move it
As amended.
as amended. Do we have a motion and a second? Those in favor?
Aye.
Any opposed? Okay, thank you. So that goes forward. Now, whew, that was hard work. Okay, now, hopefully some people are still here for the rest of the agenda. Appropriating grant funds in the sheriff's budget from Department of Homeland Security. Any questions? Did you need to share anything other than what's already in the packet with us?
No. Call the question.
No, ma'am.
Thank you. Okay, so it's,
We're here.
okay, thank you. So it's moved and seconded. All those in favor?
Aye.
Opposed? The next one, which is a tax abatement request for El Guerro's Supermarket, that would be a replacement of the certified warehouse on Jackson Street, and actually bigger than that, is going to be moved to the February agenda. The paperwork isn't totally over yet. I spoke with the city of Joliet this morning at the CCP meeting earlier. They have got the deal. They're finishing up the paperwork. They'll bring that to us.
Make a motion to remove it. Remove it, then you can bring it back when you want.
Second.
All those in favor?
Aye.
Any opposed? Authorizing the county executive to execute the necessary documents for delinquent tax programs.
Second.
All those in favor?
Aye.
Any opposed? Renewing contract for pharmaceutical and consulting services at Sunny Hill.
Second.
Favor?
Aye.
Opposition? Okay. The next one is setting the salary for the county executive legal counsel. I believe that you're going to bring that back to us.
I'm going to ask that that be tabled, not
Tabled.
removed. We will bring it back, and we will submit a full kind of detailed duties and explanation of what we're doing for the next, you'll have it in advance of the next executive committee. Thank you.
All those in favor?
Aye.
Any opposed? Okay, the next two impact the Diamond Enterprise Zone, and I believe we don't have the paperwork ready.
No, we do.
Oh, we do now
So
after
I
all?
have the
Okay.
mayor,
Oh, that's
Mayor
right, 'cause you
Terry
two were there
Crews here.
yesterday.
So-
Oh.
Well, we need to, okay, well, we need an
And we
explanation.
have with us today
But
Mayor
We've had
Kern,
her
who
sit
is
here for
proposing
2.5
that we...
hours. So, Mayor, come on. So-
Mayor Kern, thank you.
Speaker and Executive Board for meeting with me on this item today. We really appreciate it.
We do, and we're at the discussion now. Thank you.
Okay. Would you please pass this around? I don't know, I think you already got it, but just in case. Diamond, our enterprise zone was designated January 1st, 2016. And I don't know how many of you are familiar with Diamond, the humongous village of Diamond. We have 2,700 folks living in Diamond. The enterprise zone is currently 12 square miles, and our enterprise zone encompasses less than 1 square mile. So we were very excited with the opportunity to be able to offer the enterprise zone to Will County, Grundy County, other municipalities if they needed it. So in this case, I don't know if you've heard of the Grundy County Economic Development Council, but Nancy Norton approached me on behalf of Competitive Power Ventures. They would like to be included in our enterprise zone, and they are doing a $1 billion privately funded 1,100 megawatt natural gas powered 2x1 combined cycle facility that will provide electricity to power 1.1 million homes. It's a 30-acre site in unincorporated Grundy County. It's in the Three Rivers area, just south of Exelon's Dresden Generating Station. In Goose Lake and southwest of the mouth of the Kankakee River. We're very excited that this project will create 500 construction union jobs for about 2.5 years, and after it's open, there'll be 25 full-time, very high-paying jobs with a $3 million payroll and benefit package. So we believe this is a regional project, which is what we wanted to get involved in. We're a small community. I have 8 employees. We can't handle a lot of these, but if they're regional, we can definitely do it. So Exelon actually welcomes CPV and does not see the project impacting them. What we need from both Grundy and Will County, because we have a map, and I included the map that we'll use for the route in your packet. This is not a physical route. We don't annex property, we don't get easements, but this is a route that will connect to CPV and allow us to put them in our enterprise zone. They actually calculate the route is 3 foot wide, and that is calculated into the acreage that will be removed from our 12 square miles. So that is what the route does. Grundy County currently is in the LaSalle, Ottawa, Grundy County Enterprise Zone. They only have 3 square miles. So they're trying to use their 3 square miles prudently. And Nancy's idea was to put CPV in the Diamond Enterprise Zone so that they could save their remaining acreage when they redevelop the shuttered Collins Station. So I can understand her reasoning on that. It makes a lot of sense. And this will be the first major project in our enterprise zone that Diamond does. So the idea of doing a $1 billion project is very appealing for me. It gives us credibility that will be a good zone. So what we need from Will County is simply the ability to move through a portion of unincorporated Will County property and then through the unincorporated Grundy County property to get to CPV. So that's why I'm here today. We have an intergovernmental agreement, and today I'm requesting that you consider adopting a resolution that will allow and authorize the county executive to sign the intergovernmental agreement. At that point, we will know, Grundy County signed theirs earlier this week, so they're already on board. We needed to know before we got much further that both counties were actually on board. After you do that, Diamond will approve the intergovernmental agreements with both counties, and then we'll have a public hearing, and then Grundy and Will County will both adopt ordinances. At that point, we'll prepare the state application, and it will come back to both counties for signature. So there is a very lengthy process regarding enterprise zones, and we are trying to stick through that process. So Nick, I'll turn it over to you.
And I'll just say before Nick comes on, he's going to join us, is this allows us to be good neighbors without any actual expense to us. And it's, as Mayor Curran has said, it is a regional thing, so it allows us to participate in that wise. Nick?
So we put both items on the agenda just to give us maximum flexibility. This is just, those of you who've been through this before, sometimes we do the IGA and the ordinance at the same time. What the mayor is requesting, just that we approve the resolution that gives the county executive the authority to sign the IGA, but we, and I'll defer to Mary if she wants to jump in, we won't sign the IGA until they bring back the ordinance and do it all at once, because the IGA requires references to the ordinance. But this, as the mayor said, this gives them the ability to know that the county's on board. It really doesn't impact Will County directly, but it does, the jobs are there for our residents to go right across the border. Diamond is a Will County community also, and they've been good partners, and as Denise said, it's a regional approach. And this is very similar to, we've had other projects like this. The J Power is a similar type project that's in Will County, but any questions, we can defer to Mary or...
Okay, and Jackie had a question.
I just wanted to say kudos to the mayor and her staff for providing us a document that is environmentally friendly. I have never seen this kind of staple before. Some of you may have. I just want to point it out and suggest that maybe we could consider doing this in Will County. Very friendly to your paper shredder, doesn't, waste any natural minerals in our country or whatever we make staples out of these days. For all I know, they're made out of plastic or chemical, but I don't think so.
Still metal.
Yeah, I think they're still metal. Lord knows where we get it.
I just bought a new shredder to shred staples.
I got one of those too, but I'd prefer not to have to worry about it. Plus, staples are painful, they're injurious, they're nasty. This is really cool.
Okay, thank you, Jackie.
Thank
You had a
you.
question here.
Yeah, I do understand cooperation and regional projects and how it does benefit our regions, but I'm just curious, Mayor, what direct benefit for Diamond? I'm not worried about Will County, but is there going to be any direct
Well,
benefit to Diamond?
this is our test. I sold it to my board that we wanted to be good neighbors and help others with our enterprise zone. When you are an enterprise zone, you can charge a fee, and the fee can be, I believe it's 0.5% of the total construction cost. So not to exceed $50,000. So in this particular case, the Village of Diamond will bill $50,000. Now, we have a enterprise zone administrator, and he and I will actually, when the contractors start working for this project, they will need to be entered into the state website, and a certificate created so that they can purchase their construction material with no sales tax.
Right.
So it will generate a lot of work on our part to do that. I anticipate probably 50 contractors, maybe 100. So this is the test to make sure I have not extended Diamond further than we can successfully handle. I'm learning it myself as we go so that I can assist. But this is the first time we've done it. We've never helped anyone before. On other projects that are smaller, then the fee would be much lower. And that's a new thing that the state did, because prior to this, they were allowed to require much heftier fees, and I suspect maybe the state thought it was getting out of hand. So they did absolutely clamp down on fees.
Okay, thanks.
Anything else? Okay, so before Denise stepped out, she reminded me that there's already a motion and a second on the floor. So now we can call for a vote. All in favor? Aye. Opposed? Motion passes.
Thank you so much. I really appreciate it.
You're welcome.
And hopefully someday we can be of assistance to Will County. So we'll look forward to doing that. Thank you so much.
Okay, next on the agenda, discussion regarding recapture money from Laraway Sewer and Water.
We should probably remove number 9 from the agenda. That could be...
Oh, okay. Okay. All in favor? Aye. All right. Next on the agenda, number 10, discussion regarding recapture money from Laraway Sewer and Water.
I'll be very brief. This, as many board members who've been here know, the Public Safety Complex required us to get sewer and water to the facility. We worked through City of Joliet. As one of the many IGAs we did with them, we included a recapture agreement, which is often done at municipal levels, but we can do it too with their help. We did a recapture agreement for this project, and Estes Express Line Trucking, which is at the corner of Laraway and 52, located there. They were required to pay us $100,000. The copy of that check is in your packet. In discussing with staff, both in the Executive's Office, the County Board Office, the financial staff, we're recommending that this funds, these $100,000 go into the Capital Facility Replacement Fund 315. We had tried to we've been putting money in that, but this just adds to that. And so we wanted, one, this is a positive. Two, we just want to get formal direction, and we'll draft a simple resolution that just says we accept this money and it's going to go in that fund. So that's the recommendation.
Okay. All those in favor?
Aye.
Any opposed? Thank you. And I believe the next one we are going to move, we need some further discussion on that.
Well, the next item is the South Carolina Drive traffic.
Well, they need a motion and yeah, we did.
Jim made a motion.
Didn't they just vote on it?
Second, yeah.
I think they just voted.
And we didn't have a second.
Okay.
Jim made the motion.
Oh, sorry.
Yeah, we did, but we got it now.
So
Okay.
the next item is something that we've been working on in Public Works, but this came to this committee, I think, because did we not have we had a Public Works committee? I don't know. I think we didn't make it in time. But if this could be considered an executive session, because this is a negotiation item.
Okay.
So if I know we're going to executive session on other issues, so if that can be covered today, that would allow us, if we get direction, we could keep moving. So, but this would be on negotiation for a lighting.
Do you need a motion to move into executive?
I'm not sure you can go into executive session for this, because even if it's negotiating contracts, there's a limited subject.
Okay, that's fine, we can talk about it. I mean, we've talked about it in public session, I think, so.
I'm sorry, what did you say, Mary? What was your final decision?
I don't think this particular issue can go into executive session. We're not acquiring real estate, we're not talking about labor negotiations.
Okay.
We're limited in what we can go to executive session for negotiations.
Okay, we are talking about, though, methods of payment and who pays what. No, okay. Okay,
fine.
that's fine. That's
doesn't matter
fine,
to me.
thank you. So then,
Then I think we should,
Are we ready?
I'd like to talk about it then, it's just to
Okay.
get some direction from the board. So
Okay.
this is a long-term project request that came from the Carillon community, which is on Weber Road. It's been talked extensively on and off again at the Public Works Committee. The Carillon community there was begun, I believe, in 1989, and that was long before Weber Road, what it is today with the traffic. With the construction of the Weber Road interchange north of there, this community came to the county and asked for a signal at South Carolina Drive. I've been told by the previous county engineer, and now Jeff has come on, so this has been a long-term project, that would be the likely location of a signal should development occur on the east side of the street, which is likely to occur when is anybody's guess. But the county board passed a resolution quite some time ago that supported the light, but there was no funding to the light. And then we had discussion loosely at the committee about that in theory, some say they should pay for it all. They are asking for a consideration for the county to pay. We said to them, make an offer so we can have actual negotiations. We received a letter, I think it's in your packet, that they're proposing $45,000 for the construction of the signal and $5,000, which is the annual cost that they've been told they have to pay. The total cost for I'm going to wrap up 1 second, Don. The total cost that our current county engineer estimated was $230,000 for design and construction of this temporary signal. So their group proposed $45,000 plus the operational cost. I guess first thing is, that's the offer.
Right.
The board has to say, if that's adequate, that's not enough, do you want to give me direction to go back? And we have a recommendation if you want to go a different direction, so.
Okay. First question, Don.
Is some more background information into this, is that the committee also received a legal opinion from the state's attorney's office that said that this is a private street into a private development, and if we were to pay for this stoplight signal intersection improvement for private development, it could open us up for liabilities of having to pay for future improvements to other private developments where somebody needs a light improvement or turn lanes or whatever. It sets a bad precedent, is what I believe, Mary? Is that correct? Correct. The other thing is, we also, in the committee, we also offered to them the ability to make payments on this over time. I think we said 3 years we would allow them to pay for it. And I think at one time I looked at the numbers, and it was like $90 per person that lives in the Carillon subdivision, and they would have 3 years to pay that as if they collected a special assessment or something. So I don't think it's a crazy number for them to pay for the intersection improvement themselves. And that's just bringing everybody up to speed with things that have been discussed in committee over several different meetings.
Okay, thank you, Jim.
Mary, just to follow on your thing, why am I thinking that? I thought there was an opinion that we could not spend money on a private road.
Well, we can't spend money on a private road. This is akin to a development like a Menards.
Yeah.
If Menards built and they created more traffic, then they have to pay for the light to accommodate their development. And this is the same thing. This road is a private road. It is not open to the general public, and they are now requesting that a light be put there. So that would be how I would set forth for the comparison.
So part of the project would be on a public road.
Correct.
Weber Road.
Correct.
And then part of it would be on a private road.
Right.
So we would have to make the determination, what's the cost on the public side and what's the cost on the private side. Just to be fair, I mean, so it's all private road.
But,
okay. That's all I want.
Okay. Question, Jackie?
I like that concept of what Jim pointed out, it's kind of half and half. However, I go back to what Don said, there wouldn't even be a need if that private road and that private subdivision didn't exist.
Well-
I mean, I think about like in Bolingbrook at Winston Village Drive and Boughton Road, there is a light there and it goes right into Winston Village, but you can keep going on it. and go to many other neighborhoods. It's not private, it's not just for that subdivision. This light is just for that subdivision. So just something to keep in mind. I'm not sure whether I'm for or against it, but it is just for that subdivision.
Okay, Nick?
It's your decision within the legal ramifications, but the private road that we're talking about, South Carolina Drive, was granted many years ago, and that was built on the plan at the time because they paid for, I believe, the access at North Carolina Road, and there's a signal which they continue to pay maintenance on that signal, and they paid their share because it's often, and Jeff can explain this better than I, the quadrants of responsibility, but they paid their share of that signal. But the development, anybody who's lived in this area knows that Weber Road was not as busy 20, 30 years ago as it is now. And it's not because Carillon is built out. They have no further expansion. If they were coming in today, they would be required to pay based on the density and the impact they would have on Weber Road. And what's going to happen, is my understanding, is when the development comes on the east side of the street, they will be responsible for half the cost of the permanent signal, which is going to be there because they're half the two quadrants on the east. On the west side, where Carillon is, they're in the northwest quadrant. The southwest quadrant is ComEd property. So the thought of 25% of the cost of the temporary signal was based on that assumption. Whether we agree, because it's happening because they're requesting, not because, but since this process began and since we're at today, it was not warranted at the beginning by traffic count, and now the DOT, our county DOT has said it is warranted by the numbers. It's just who's paying for it. And we're talking about $230,000. I'll defer to Mark Ferry and Tim Krolitis, who are the representatives, but they've heard it.
Wait. And Beth and myself.
You represent the east side of the street. You don't represent Carillon or the residents who live there. But the residents have an argument. If, Mark, you want to explain their...
Well, their argument is that they maintain all of their own streets and within Carillon, and that's very costly to do. But they also pay $7.9 million in real estate tax and support 2 school systems. Now, we all do that, but again, they do take care of their own roadways, and it is a safety issue in this case. Also, the ambulance calls into a senior citizen development like that need to be able to get through, and if you have traffic jams at the only place, hopefully they can get in the other end. That's hopefully, but a light I think might help that. And it's mainly a safety issue that they formed their own safety committee to even start their approach to everything. So it's separate from the CAMA Association, which is Carillon Association, so neighborhood association. So as far as they're concerned, they think, and I hope I'm saying it exactly right, they think for the $7.9 million that they pay in taxes, they're not asking too much for something that ensures their safety.
Okay. Don?
We held a meeting, an informational meeting at Carillon. I hosted an informational meeting at Carillon several years ago with, during the planning segments with IDOT. We brought in the Lockport Fire Department, the Lockport Township Fire Department, the Romeoville Fire Department. We were assured by them that there was a plan, that there was not going to be any issue as far as ambulance rides in and out of the facility during construction. There's 2 other lighted intersections that come out of the subdivision right now, North Carillon Drive, and there's one also at, in between North Carillon Drive and 135th Street that they can exit at either North Carillon or they can exit at 135th Street from that other exit. I'm a little leery, and the $7.9 million? $7.9 million that they pay in property taxes doesn't come back to us to pay for road improvements. Only 7% of their total real estate tax bill comes back to the county to start with, and that's all inclusive of all the facilities and things that the county provides, not just, we don't provide schools, so the school districts that they pay for, the fire protection districts that they pay for as part of the real estate taxes aren't anything that the county receives.
Yeah, okay. Judy?
So I just wanted to ask a question. Whose responsibility is Weber Road then? Is that ours?
Yeah. Weber Road is a county highway, yes.
It's a county highway. My only concern is if they're requesting it and for some reason we don't do it and there were an accident there, would we be liable? We would not be liable. Okay, thank you.
Okay. Okay, and Nick, you had a proposal?
Well, I guess the question is, we just need to respond to these folks, because they've spent an incredible amount of time, and county staff has spent a lot of time going to these meetings, and the county passed a resolution, said they're supportive of it, but unfortunately didn't specify funding specifically. Well, I mean, they left with the impression that you support them, and I mean, and then the committee said, we'll get a proposal. So they've submitted a proposal. It's taken them some time because they had internal discussion. So if I just need to know what the response is going to be, or somebody needs to respond to them effectively and say, this is yes, no, or we want to counter offer.
Okay, let's get the engineer first, then Jim. Jeff?
Just a couple other facts to keep in mind. The temporary signals being proposed, it would be completely within Weber Road right-of-way. So it would be all on our right-of-way, except maybe a few detector loops, a couple feet, no big deal.
Okay.
Nick was correct on the overall cost we estimated over a year ago. This proposal, $45,000, you can take that for your own consideration. I do not know with this $5,000, is it annual or not? Because the annual maintenance is an annual maintenance, somewhere between $3,000 and $5,000. So I don't know if they're saying here this is annual or a one-time payment, so that's something to consider. And then, this is just for the temporary. When we do the multi-lane expanded again, we have to take out that temporary and put in a permanent. That retrofit will be $350,000. So if it was a Menards, we would put that expense on Menards or a development. So there is that expense as well. So who's paying for that expense?
I know it's Jim, but after Jim, I have a question.
Well, just for the sake of trying to move this along a little bit, here's what I'm thinking. First, Jeff, I don't know if a temporary light puts any infrastructure in that you would be used for a permanent light.
Very, very little, negligible.
So, and what I guess I'm really trying to get down to is, what do we think a reasonable cost would be? I mean, are you saying, Jeff, that there would be zero cost to the county because we'd be doing nothing otherwise, correct?
If this was
if we weren't doing anything on the signal, then I assume that the cost to the county is zero.
Correct.
Okay. And you've looked at this in the past. The first said it just didn't qualify to put a temporary signal there. And then my recollection is that then maybe it barely met the minimum standard of a signal there. And what that means is that if it far exceeded the standard, I assume we would be putting it in.
Yeah, originally, it did not with our traffic counts. Then we did another one right before your vote, actually, and it was one car shy, but but that warrant is based on traffic of the side street, not of Weber.
Yeah.
So that's based on the side street traffic.
So I guess what I'm saying is that, do we take another look at it? Do we apply 100% of the cost? I think they've made I think we did pass a resolution saying we supported the light. Right. But we also said
they had to pay for it.
We're not going to pay for it, right? I mean, whether we should pay for a portion or pay for nothing, I guess that's the determination. I think it has to be a little bit more than what they're offering. I'd like to see if there's going to be any other. If the signal goes in, Jeff, what I would ask is, and I want you to be as objective as you can. Which I know sometimes for engineers is a little tough. It's either A or B.
We're black and white.
But is there going to be benefit to the general public, and would there be benefit to the project if the light were there? I mean, and I'm not looking for you to pull it off the top of your head now, but I still think it's something that we have to ask. Is there a benefit to the general public going up and down Weber Road? Does it now go maybe a little beyond the standard? So I still think maybe we need some additional information to move forward, Nick. Now that we know that they're serious about contributing.
Okay. You turn that off, please.
The question was for Jeff.
So the other question I guess I'd have, just so we're all on the same page, is the county, since it's the county highway system, we granted them access at some point in the past, years ago. But now they have access. When development, because it's likely to come someday, we don't know when, but on the east side, they're going to be, if the county signal is warranted at that intersection to support the development on the east side, Carillon on the west side, and the north-south flow of traffic, what is the break? I mean, first of all, they're going to be required to pay at least a quarter of the price, right? Who? Carillon, because they have access from South Carillon Drive, so they're going to have to pay a portion of the signal. It's not, the county's not going to come in and pay for the whole signal for the development on both sides of the street, right?
Well, our permit would just be with the developer on the other side. Where they get their money, I don't care.
So you're not going to require, so Carillon wouldn't necessarily be on the hook for that?
Not necessarily.
Okay.
Okay.
So the only price or cost that Carillon could pay is whatever they're paying on the temporary site, possibly, because they're unincorporated, I believe, I mean, there are jurisdiction on the west side, and ComEd is on the south quadrant of that side of the street. So, and the thing, just as an advocacy for the residents, yes, it's a private road has public access because that goes into their golf course there, so it's not completely, it's not a gate at the street, you can't come in. The public goes in there to go to their golf course, but they're accessing a very heavy used county highway. So the people going north-south, whether they ever enter Carillon or not, could have, and there hasn't been a ton, thankfully, but there could be accidents there with people making lefts out or lefts in. That's the safety issue that was why we brought this forward in the first place, so.
Yeah, okay. Don?
One thing, the golf course is owned by the subdivision, okay, so they make a profit off of it, just like at Menards would on the other side of the street. Number two, if we put a temporary signal in there, and the construction on our current phase of Weber Road finishes, and we go to the next phase, which starts at or about that light, going southbound, right, to add the next lanes between there and Airport Road. That temporary signal will have to be turned into a permanent signal at that point, whether development comes on the east side of the road or not. You're not going to put in a signal that's temporary and then you're going to take it out and have no signal there. Is that correct?
You could take it out. There's nothing saying it has to go back. I mean, you could take it out. I'm not sure I've seen that happen.
Is it reasonable that you would do that?
He would.
Take it out, I mean.
We have a temporary signal on Brake Street that's been there 15 years.
Yeah, but we didn't widen the road at that point yet.
So reasonably, you would, once the temporary is in, you would replace that with a permanent?
Yes. You would
Okay.
go back to permanent.
So we could incur the total cost of the permanent light. If Carillon said, we don't have the money at that point to pay it, and we're now required to put in a permanent light, or we decide we're going to put in a permanent light.
Yeah, if there's no developer on the other side,
So another
then yes.
$300,000 or whatever you said the price was for a permanent
Or
light.
you could put a recapture agreement with the Village of Romeoville when they do develop it, that, just like we just did on the sewer and water project, we can do a recapture agreement.
Yeah. Okay. Okay, so we have a lot of options there. So one of the options, if I'm listening correctly, or tracking, is that we accept the money from them, and then we shell out the rest of the cost of that light for the temporary signal. That would be one that's on the table. A second would be to go back to them and say, and I may not have heard that in this meeting, I may have heard that someplace else, that we go back to them and say the amount that could be spent would be larger than what they proposed, but we spread it over more, oh, I think you just said it earlier, that we spread it over more years. That was Don who said that. Spread that over more years, so they have a bigger share in it, but they don't have to do it all on the front end, which means, though, that the balance of the cost of the light would be still borne by us. On top of that, at the point that there would be a permanent signal, we would still be bearing all of the cost unless there is a developer on the east side who would then be responsible for a portion of it. Is that all the scenarios?
Our current IGAs that we have set up with is future improvements are borne by whoever
comes in. So
would be
that
the
would be on the east
development.
side.
So such as North Carolina, they are actually contributing towards, North Carolina, the CAMA is, they're actually contributing $90,000 towards that future signal per the existing agreement. So.
Okay, so if we don't get a developer on the east, then the likelihood of us having a permanent signal there is limited. Is that true? No, because as we widen the road, we're going to put one in anyway. Yeah. Yeah.
Just someone has to pay for it.
The temporary would just still stay
A friend
there.
of mine ran for mayor once, in a small town in Illinois, on the premise that there was a stop sign on every street corner, and he was going to take some of the stop signs out, but after he talked to his city attorney, we would talk to our state's attorney, and she'd say, you have this existing temporary signal here, chances are pretty good you don't want to take that out, because then people are going to be expecting a signal to be there, they're going to blow through the intersection.
Yeah, you don't want to set yourself up like that. Yeah, that looks like trouble.
My premise is that if you put in a temporary light, we bought a permanent right there, one way or another.
Yeah, that sounds like it.
Nick, you brought something up that we haven't really discussed in the past, and that is talking to Romeoville about recapture if we put a permanent signal in. And the reason I'm saying permanent signal is because rather than put a temporary signal in, we put the permanent signal in. If we can get a recapture with Romeoville, I think it's worth a discussion. I mean, we haven't tried, right?
Right.
I think we should at least ask them what their thoughts are about
I've
recapture.
had initial discussions with the village of Romeoville on that, but I don't believe, and Jeff can help me on this, is can we put the permanent signal in right now, or because you're gonna widen it in the
Right,
future.
we would have to rip it out.
So it's going to have to be if you're going to put a signal in, it's going to have to be a temporary signal to be replaced by a permanent signal. Some of the infrastructure might...
I'm thinking about more infrastructure. I'm not talking about the light that dangs from but the infrastructure.
I mean, you're going to have to run power if it's not already there to the nearby, but like Jeff and I have had this discussion. The actual equipment is not going to be the same. You're going to have to replace that, so. But there are other options when you get to the permanent signal if there's development, because the executive's office has participated in discussions at other places in the county where there's been economic development projects, but there's also other places on that same road, which was mentioned in committee, where there's signals up that have never been turned on or a steady green because there's no development there either, which there's a little bit of a gamble on when it's going to come.
I just wanted to see if we've actually had that conversation with Romeoville about recapture and so forth.
We're still going to have, if we're going to do a signal anytime soon, it's going to be a temporary signal to be replaced in the future by a permanent signal, because there's different equipment. So.
Sure, Gloria.
So, Jeff, just as clarification, in the proposal that you have right now, with the widening of Weber Road, you get all your directions.
Might have to leave at 1:30.
I wish I could.
Just letting you-
Happening right now is actually a different project than, this is
It's all
just
north
the
of
very
that.
tip of it. But the phase one study that we're completing right now is not include the
Okay.
How about for sake of time,
Thank you.
go back, Nick, and tell him, thank him for the offer, and we're looking at it, and we're going to crunch some more numbers, and we're going to get back to him.
Sounds good.
Sounds good?
At the same time, some deeper discussions with Mayor Noak about possible recapture, if we can do anything along that line.
I mean, we've had to wait almost a year to just even get this number from them, so clearly they're not in that big of a hurry.
We're gonna come back with something.
No, but, yeah, we're gonna do something with that.
We're gonna do
So if we
something.
could,
They'll hear
you know,
back from us.
put some things together like that, that would be great. Thank you.
Thanks, Jim. Okay.
Okay, number 12, authorizing an intergovernmental agreement between the city of Lockport and Will for maintenance and, yeah, I can't even see the thing. 143rd Street package.
143rd.
3rd Street package. Move. Is there a second?
Second.
All those in favor?
Aye.
Any opposed? Authorizing the county executive to execute amendment for OPEB retiree trust. That was as a result of this morning, yeah, okay.
I have a question.
Question?
What did we change?
I wasn't there, I was at a different meeting.
Yeah, just clerical stuff.
It's the items on page 1 and 2 of the agreement. So this is in your back. Just minor changes.
Nothing substantive.
Thank you. Okay, so we have a motion and a second. All those in favor?
Aye.
Any opposed? New recycling drop-off in
Moved.
Crest Hill, that's just a discussion.
Is it this good?
All right.
Dean?
Just wanted to, we just wanted to let you know that Highway Department is allowing us, Jeff and to obtain 3 acres.
That's
Just-
at the Caton Farm?
Caton Farm.
Roadside,
Yeah, I did
okay.
mention it to Denise a little while ago. But, and so they've offered this for 3 years, but we never had any money in the budget to start it. So we do have it this year to start it, not to finish it. So the idea is we have a lot of people that want to bring latex paint somewhere. We used to have an agreement with New Lenox Township, and that's gone away now, to bring latex paint. And our events, half of the cost is latex paint. So if we had a place to bring the latex paint year-round, our residents would have a place to bring it, first of all, instead of, say, Ace Hardware, which is like $3.50 a gallon.
Yeah, so that would be the Caton Farm side. I'm going to speed you up, Dean.
Right, so what I'm just letting you know is what we're trying to...
So
Go
the
ahead.
thing you need from us today and is to...
Okay, what I wanted to do was tell you about it so that in a month or two, when I come back and I say, it's going to cost this much if we do this much, then I just don't want you to be surprised.
Okay.
That's the whole point of me coming today, so you know what we're doing. We're not doing behind the scenes. We're going to go talk to Crest Hill about what they expect from us and work with the Highway Department. That's the whole point of this discussion today. That's it.
Thank you.
All right?
Thank you, appreciate
Here you
that.
go. Good job, Mark.
Thank you, Dean.
Good job, Mark.
Okay, and then we're renewing the contract for electronics recycling for a turnkey collection.
Moved.
All those in favor?
Aye.
Any opposed? Okay. Renewing the contract for electronics recycling, the one-day
Moved.
collection events. All those in favor?
Aye.
Any opposed? Okay. Authorizing the county executive to execute an intergovernmental agreement for Custer Park Fire. All those in favor?
Aye.
Any opposed? Replacement hire for supervisor assessments office.
Second.
All those in favor?
Aye.
Any opposed? Replacement hire for Sunny Hill.
Second.
Any opposed? Another replacement hire for Sunny Hill, that's the food and nutrition services.
Second.
All those in favor?
Aye.
The next one, we're going to move, 21, we're going to move to executive. 22, presentation to the, not for me. Presentation to the county board on energy savings programs and renewable energy, Samantha. And this one we're going to, do I see Sam out there? This is the one we're going to put on for the...
Jim, I let Sam go back to it.
Okay, this is the one that we're going to put on for Committee of the Whole for February.
Addition Energy, our energy procurement
Right.
company that's saving us the 130, 140,000 a year. They're going to come and give an energy market update, and then Sam will talk about all the stuff that's been going on in the last year, or since she's been with you guys. So
And that'll be a committee of the whole on February 14th,
I
that's the
thought that one was just a solar farm
update it is.
update and explanation for everybody. I thought this was a presentation at the board meeting.
Yes,
This is separate, this is prior to that one. Okay, so this one will be next Thursday.
Moving it to the board, yes.
So this will be next Thursday,
There's going to be a committee of the whole.
on the 14th. Question, Ken?
I just had a question about 21, if you want to finish this one.
21's moving to the executive committee. What's your
Executive
question?
committee.
Executive session.
I mean, executive session,
Oh,
yes.
today.
Yes.
Okay.
Okay.
So we just need a motion to put that on the county board agenda. 22.
All those in favor? Aye. Okay, any opposed? Okay, we had a couple proclamations, you all, one, okay, is that right? You all had the
We
sheet?
have one additional that just came in yesterday, if we could. Sister
Vivian.
Hernandez that
Right.
established the Community for Correctional Concerns. It's the 40th anniversary of her founding it. And she's
Not in
going
the
to be
budget. I spent it all.
recognized at the state of the
Courthouse on the 23rd.
We'll just read something into the record.
Record on the desk, and then I'll share it with, at that event.
Both of them will be just read into the record.
Right. Mhm, you had a question?
Yeah, Denise, I know on 21, wait, that's what I want to talk about. You know, this deals with the compensation of the supervisor assessments, who's under contract through 2019.
Right.
So it's under contract. I'm going to suggest that we just remove this. We don't even address it now, and that it's addressed more when we get talk about other salaries, budget items. I'm thinking, I don't think we need to do this now, so I think we should just remove, I'm going to throw out the possibility or the thought of, just remove it. And this is something that we need to take up later when we talk about other people's salaries too, and so forth. So anyways, I'm just going to throw that out
Let me
there.
just share this with you so that it might be more clear. The discussion in executive will not include any salary because the salary is going to remain constant. If that's helpful for people, it is just to agree that the contract will remain in place.
Well, the contract is in place.
Through 19, but that is for the next 4 years.
And I don't...
But now, let me just say this
Okay.
before you go further.
Yeah, go ahead.
Is that since the contract, I believe, comes from the executive's office, is that correct? It doesn't have to be a contract, but the appointment, I should say it like that, comes from the executive's office. Given that that's the case, there probably is not a need for us to do anything then, since we are agreeing that the salary, which is set through the end of 19, stays
contract.
as it is, under the contract. Any future appointments or contracts will come from the executive's office. Do we need to, Mary, do anything else?
You don't need to do anything else. And I don't know that there is a contract in place. I think that you just set her salaries last time.
But that's through the end of the year.
I'm not sure what the other appointments.
The appointment comes from the executive's office, as Denise stated, with the advice and consent of the board, and it's like, we already got a contract.
I mean, it's been done both ways. Rhonda had a contract, the supervisor assessment had a contract previously, and then we didn't do a second contract. Why, I don't know. But the contracts generally give both sides stability in knowing that, I mean, if you say it's set at this rate for the next 4 years, it's not going to go up, it's not going to go down unless you both mutually agree to change it. And I think it may make sense to do that just because of all the concerns, volatility on this in the past, that it just say, here's what it is, and it's done. And then the only way to change it is to mutually agree to something different. But unless there's an inclination to do something different.
Well, Nick, then I would ask the executive's office to request and forward your suggestion on the contract. If you want to do another 3-year, 4-year, 5-year contract.
I think that, I mean, and as I said last week in executive, but I'll say it here because we did not draft the contract, the supervisor assessment worked with the state's attorney and drafted, so there is an existing contract that's ready, that states a 4-year, no increase, stays the same, exactly the same. I think that we can provide, and if it's appropriate, put it on next week's board meeting and approve it. Let's get it done.
I would be down with it. If you want to bring a 4-year contract under the current terms for the next 4 years,
and it's been,
I'm good with that.
And the state's
I don't think we need to
That answers
reinvent the wheel here. Yeah.
Okay, so you have your light on. Ken, did you have another question?
Yeah, I was just kind of unclear. Jim just made a suggestion we had to take the current contract for another 4 years?
No. There has been a proposed contract for the supervisor of assessments covering the next 4 years at the current rate. So there is no increase in it. It stays the same, duties, all responsibilities at the current rate. So there is no increase at all. So the suggestion is that we accept that, bring it forward at the full board, and vote that.
And if we wanted to change the rates, how would we do that?
Then you would have to have some other resolution. The rates, we're proposing that they stay the same.
We're saying that everything stays the same.
That's not attached to this resolution.
It is not attached to this resolution. We can have it attached in time for next week's board meeting, but I will say that it looks exactly the same as the one you saw before. The only difference is that the salary then would stay the same over the 4 years beyond December of 2019, which is what the current contract allows. So that would be the difference is the new contract, which I'm guessing is not attached, I didn't check, is not attached, would show that in that part, for the next 4, the salary stays the same. So,
I'll make
the
a
question
motion that
then-
we place that on the agenda for
Second.
full board consideration. All right, Nick? All right, thanks.
All those in
Good.
favor?
Aye.
Any opposed? Does that satisfy your concern, Ken,
Somewhat.
or no?
You can still ask more questions.
Yeah.
I'm just trying to move this
And,
stuff along.
yeah, thank you. But what may be helpful for you is that as we go into the next round of salary considerations or whatever, a year from now or whatever, if there is appetite
Always amend
to make some changes, that could happen. Yes. Does that answer your concern?
More increases.
Yeah, okay. All right, thank you.
All right.
Okay, any other new business? Oh, we had appointments to the boards and commissions.
I'll move.
All those in favor?
Aye.
Okay. That was the end of,
We saved a space for one more maintenance worker replacement hire.
right, right. And what that was, is we had approved that before. Person got there, got all the way to the door and changed their mind. So now we have to go back to the list and put somebody in. So just so that we can clean that up, we want to put somebody in there.
I'll move on that.
Second?
Yes.
All in favor?
I think Judy has a question.
Any opposed?
No.
No, okay, now your question.
Yeah, no, I just had a question or a comment really about the appointments, which we didn't have any conversation about. I know we do appointments all the time, and I see that this month we have two new board members that are being appointed to new positions, two boards, and they don't really have any background on the board yet. I don't know, I just think that it would be a good idea when we appoint to certain boards outside of here, that those individuals, county board members, have some experience being a county board member versus just being a new elected, because there's so much to learn, and that's just my opinion on that.
Thank you. Okay, any other new business? Okay.
Yeah, if I can, I'm just going to say what Judy said has some merit to it. I certainly think that new members can bring a lot to a board, and they certainly can bring things to other boards. But I do always think it's a good idea that if a county board member is going to get appointed to something, that at least the entire county board in general knows. Here again, I'm just going to speak for kind of what I did. That was kind of like, hey, I was kind of like, hey, you want to do it? That's fine. You know, I always try to get out there that was available, and maybe you get them while they're young before they know better, because once you've been here for a while, it's hard to get anybody to go on anything, you know, because they find out what the commitment is. But I'm just saying that it's always a good idea that everybody's aware, and if county board members, if you have an interest, you got to express it to people. You know, so I'm just kind of throwing out that, yeah, I kind of acknowledge what you're saying, Judy, that, you know, we should also use the experience that we have on the board too, so that's all. Just leave it at that.
Okay. Other comments? Okay, committee reports. In the interest of time, if there are particular things in your committee that really need to get a discussion in this room, we'll do that. Otherwise, we won't.
Denise, you're good, you don't need me. I have to go.
Yeah, I
You good?
understand. Thank you.
Yeah, thanks.
Thank you, appreciate it. Thank you, Mike. Okay, land use and development. Isn't that you?
I don't need anything, I mean...
Okay, thank you. Thank you. Finance.
You don't have anything.
Okay, public works and transportation.
Nothing new.
Okay, judicial. Public health and safety. Legislative and policy.
Nothing new, absolutely happy to entertain any ideas from anybody on board.
Capital improvements.
Moving on.
And you've just heard the executive committee, there's nothing else to be put forward. Any public comment? Okay. I have no other report or announcements to add to that. We do need to go into executive session today for labor negotiations, and let's see, the personnel piece is not needed after all, so we have just the labor negotiation piece. So we need a
Motion to go into executive.
Second.
For labor negotiations, second.
we have a motion and a second. Lana, would you call the roll, please?
Barry.
Yes.
Brooks. Priscilla left. Harris.
Yes.
Markham.
Yes.
Moran.
Yes.
Ogalla. Summers. Trainier. And Winfrey, you are in
Yes.
executive session.
Thank you. Okay. Whew.